matters next week, Malik.
Anytime.
Lordship, I beg to mention item number 8, Lordship.
What happened?
That may be taken at 11:30, Lordship.
Why?
Due to some inconvenience, Lordship.
Okay. Who is appearing for the respondent? Mr. Bhuya was appearing. Kindly inform him also.
Buddha,
Kindly inform Mr. Buddha or Mr. Bhuya. Mr. Bora also you can inform. Because without them, we cannot consider. Have they got the instructions?
I do not know.
Okay, okay.
They have to take
11:30 material.
So pray for listing for read paper withdrawal.
All listing matters given.
Okay.
May it please, Your Lordship, with the consent of other parties, I beg to mention item number 40 and 41, my lord.
Okay. You are for the petitioner.
My lord.
A prayer is made on behalf of Mr. A.K. Borua, learned counsel for the petitioner for an adjournment in the matter on account of person inconvenience. Prayer is not objected to by the learned counsel for the respondents. Registry to list this matter again after
There is interim order, my lord.
2 weeks.
There is interim order.
2 weeks on a date to be fixed. Interim order passed earlier to continue till the next date only.
May I please the Lordship? My lord, I beg to mention item number 26, 27 and 29. My lord, I have received
26.
27. My lord,
Oh,
actually,
that matter.
yes, my lord. Actually, my lord, my maternal uncle has expired, so I have to go to Upper Assam immediately.
Okay. Have you
So,
informed Mr. Das?
yes, my lord, I have informed the petitioner.
26, 27 and
29.
like 26, 27 a prayer is made by Mr. P.P. Bora for an adjournment in the matter on the ground that he has to proceed to
Upper Assam.
proceed to give me a place
Khairgaon, Jorhat.
Khairgaon, in view of the death of his maternal uncle. So prayer is not prayer is made for adjournment of the matter. Huh? Prayer is on the ground. Prayer is not objected to by the learned counsel for accordingly. Registry to list this matter again. 26, 27 date Tadiasu.
Actually,
1-4.
I talked to them probably on Monday.
No,
Tuesday.
no way. So 1-4, 2026 and 29 on 2-4.
May I please, Your
Round 2 again. Yes, Mr.
Lordship. With consent of the other side, Your Lordship, I beg to mention item number 38, Your Lordship. In this
Registry
case-
to list this matter before any other bench without me.
Lords.
May please, Your Lordship. May please, Your Lordship. Also, with due consent of
The brother is an advocate of this court. The sister is an advocate of this court.
That I do. Obliged.
38.
May please, Your Lordship. Your Lordship, with due consent of the other side, I beg to mention item number 42, 42, Your Lordship.
Why?
Lordship, because I'm appealing for the BDC, records were called for. Your Lordship, the records will be here positively next week. Therefore, our date may be fixed after 2 weeks. We have taken consent from the petitioner, Your Lordship.
Mr. Todi?
Lordship. I am for the respondent 7. For the records of the selection committee, Lordship. That is, will be required, Lordship. They are taking time since November 2025 to obtain the.
It will be there positively next week, Your Lordship. A date may be fixed in 2 weeks.
Mr. N.R. Sharma, learned counsel, standing counsel, BTC, submits that the records of this election, which is required to be produced in the matter, has not been received. He assures this court that the said records would be produced on the next date of Mr. A. Todi, learned counsel for the petitioner, and Mr. A. Boro, learned counsel for the respondent number 7, have expressed urgency in the. In view of the above, registry to list this matter again on Bihur Pishoddia.
Before Bihu, my lord, any day.
Bihu. Interim order is there.
No,
Interim order is the Lordship.
You are not working.
I am working, my lord. There is a status quo.
I am working, Lordship.
You
Based
are
on the
working.
status quo, I am.
That case, I think once I.
Lordship is passed this.
They are enjoying the status quo order, my lord. That is.
Okay. Registered to list this matter again on 24/3/2026.
24, Lordship, I am.
March.
Can it be on 26, Lordship?
26. Okay. 26.
6th of March.
Much obliged.
Obliged, Lordship.
May I please, Your Lordship? Item number 33 and 34, my lord. In this case, my lord, the respondent file of affidavit in opposition, my lord. I have to apply.
Mr. A. Gauhati, learned counsel for the petitioner, submits that the respondents in the matter have filed a affidavit in opposition, and he would like to prefer to bring on record a rejoinder on behalf of the petitioner to the same. Accordingly, he prays that the matter be adjourned for 3 weeks.
2 weeks.
2 weeks. 2 weeks. Registry to prayer accepted. Registry to list this matter after 2 weeks on a date to be fixed. Yes.
May it please your lordship, with the consent of the other side, I beg to mention item number 21 for an adjournment, lordship. Lordship, the conducting counsel, Mr. S.P. Sharma, has some family medical emergency today.
A
It-
prayer is made on behalf of Mr. S.P.
Interim may
Sharma
be extended.
for an adjournment in the matter on the ground that he has a medical emergency in the prayer is not objected to by the learner. Have you taken the consent?
Yes, your lordship.
Not objected to by Ms. P. Das, learner.
Interim may be
Counsel,
extended.
Secondary education. Accordingly, registry to list this matter again after 3 weeks on a date, 2 weeks.
Interim,
Date to-
interim may be extended.
Interim is there,
Yes, lordship.
2 weeks on a date to be fixed by. Interim order passed earlier to continue. This is that fee regulation
Yes,
thing.
yes, lordship.
Interim order passed earlier to continue till the next day.
Lordship.
May I, lordship, lordship, I beg to mention item number 18, lordship. Lordship,
80.
18, 18. Lordship,
Ah.
kindly give some time, lordship, 18, lordship. Will file
You're for?
petition, lordship.
Your name?
Yes, Islam, lordship. Will file rejoinder, lordship.
You're not there in the case. You're making this.
Lordship, yes, Islam, I'm,
Oh, yes, Islam, yes.
yes, lordship.
Mr. S. Islam, learned counsel for the petitioner, submits that an affidavit has been filed by the respondent number,
No, no,
private
lordship,
respondent.
lordship, we will file, lordship, additional affidavit, lordship.
Oh,
I am for the respondent
submits
5.
that he be granted 2 weeks' time to bring on record an additional affidavit on behalf of the petitioner. Prayer is not objected to by the learned counsel for the respondents. Accordingly, registry to list this matter after 2 weeks on a date. Yes, madam.
I'm deeply obliged.
May I please, your lordship, mention item number 14.
1-4.
Yes, your lordship.
Why?
Lordship, Mrs. A. Bujabra, due to some family difficulties, she couldn't come.
A prayer is made on behalf of Ms. A. Buzarburwa, MS A. Buzarburwa, for an adjournment in the matter on the ground of some personal inconvenience. Prayer is not objected to by the learned counsel for the respondents. Accordingly, registry to list this again after 2 weeks on a date to be fixed. Yes, Mr. Burwa.
My lord, I beg to mention listing of this case, my lord, issue is the, my lord, the headmaster is given a junior, so 1 year is this pending, my lord, that may be given, otherwise this petitioner will be retired.
Next week, go back to the
Obliged.
And what were you doing for 1 year?
Case is pending, my lord.
No,
It's
what,
good.
why did you mention this?
Yes, that is one. Now,
Now you say case is pending. What
client
steps
is,
have you taken?
yes, my lord.
Blame should be shared.
My lord.
May I please, your lordship?
Yes.
Should the petitioner doesn't want to pursue this matter anymore?
Why?
He has joined some another university as an associate professor.
Miss
S. Saike.
S. Saikya, learned counsel for the petitioner, on instructions, submit that the petitioner desires not to press the present writ. Also, and accordingly, she prays, and accordingly, she prays that she be permitted to withdraw the present petition. Prayer is not objected to by the learned counsel for the respondents. Also, in view of the above submission made by the learned counsel for the petitioner, the present petition stands dismissed on withdrawal. Yes, what is your instruction?
Another development is that out of 8, 2 have been selected.
Now you, then why did you come here running? Huh? Without waiting? Now
In
that
fact,
is
madam-
also illegal. You said only 8 has been, we'll stay everything now.
Like, in fact, this is a continuous process, my lord. Only then, my lord, it could not be finalized because the posts were not there, my lord. Now,
I have heard Mr. M. Khan, learned counsel for the petition. Also heard Mr. P. Kaushik, learned standing counsel, secondary education department, appearing for the secondary education department. The petitioner in the present proceeding has raised a grievance with regard to the manner in which the posts of headmaster in various provincialized schools in the district of Hailakandi is being filled up, which is being filled up. Full stop. It is contended by the petition, learned counsel for the, it is contended by the petitioner that the recruitment process initiated is in clear violation of the provisions of the Assam Secondary Education Provincialized School Service Rules 2018. Also, Mr. B. Kaushik, learned counsel for the learned standing counsel for the Department of School Education, Secondary Education, Department of Secondary, has placed on record the instructions received by him from the Director of Secondary Education, Assam. So this court has perused the said instructions and finds that out of the 4 petitioners involved in the present petition, 2 petitioners.
Lordship, that is wrong. We have not been selected.
Mr. I am saying from his instructions what I have found. Whether it is correct or not, that is something to be in the at least the English that I can understand from here. That is what is written here. Now, will they be appointed?
Well, it's a process which is going on. And
projects-
2 are already there in the gradation list.
From the said instruction, a perusal of the said instruction reveals that petition number 1 and petition number 4 have been included in the final gradation list at serial number 12 and 49, while the names of the petition number 2 and petition number 3 is not so reflected. It is further projected in the said written instructions that the process to fill up the post of headmasters in various provincialized schools in the district of Hailakandi was initially initiated in the year 2003, and at that relevant point of time, 9 vacancies were not filled up due to non-availability of eligible candidate within the reserve rooster points involved, as well as on account of the fact that the candidates recommended by the district selection committee had not produced all the relevant documents. Also, it is further projected that the remaining vacancies would be filled up after necessary upgradation of the roster register. Full stop. The said issue brought on record would now mandate. Full stop. The learned counsel for the petition, on the other hand, has submitted that from the approved gradation list, appointments are being made on a pick and choose basis. Also, however, he has not demonstrated that persons junior to the petitioners are also being now contemplated to be so appointed. So, in view of the above position, the above position emanating in the matter would require a further consideration by this court, and the same would be permissible after the respondents have filed a detailed affidavit in the matter. Also, accordingly, in view of the above, issue notice returnable 4 weeks. Mr. B. Kaushik, learned standing counsel, Secondary Education Department, accepts notice on behalf of respondent number 1, 2, and 3.
1, 2, 3, and 5.
While Ms. K. Fukan, a learned government advocate, accepts notice on behalf of the respondent number 4. No formal notice is required. As all the respondents are represented, no formal notice is required to be issued. However, requisite extra copies of the petition be furnished to the learned counsel for the respondents. Also, now, which are the posts? Are the posts in the school of the petitioners being also brought in?
Yes, Lordship. Yes, fine.
That I cannot say, my lord.
That's what we wanted Mr. Christie yesterday to receive.
No, because this is a district gradation list. From the district gradation list, those posts, my lord, it's not necessary that this post will be filled up.
even if it is filled up, my lord, that petitioner will also have no right to say that only this post I should be kept vacant.
The recruitment exercise underway and the promotions and the appointments and the promotions thereon made to the post of headmaster would be subject to further orders that would be passed by this court.
Not only two candidates, only two candidates have been selected out of 31. I not these four petitioners.
that
Two candidates have been selected in Hailakandi district.
Out of Lordship, this 8 candidates forwarded selected by
Where
the.
do I get that
Yes,
information?
Hailakandi district, only two people. Have given the tick mark, Lordship.
So rest are from other districts.
Other district. So this post of this 4 petitioner Lordship may not be disturbed.
That posts are
No,
not your
That
posts.
posts are not there.
These are now district level.
No,
posts.
District
their
level.
posting is
And
not
two-
given.
two post petitioners only, at the best, 2 petitioners would be affected, not
Affected.
others.
And my lord, I have been told, my lord, there are enough number of posts. It's a continuing process, my lord. In the process, my lord, if these 2 petitioners are found eligible, they will be given a post.
Mr. Kosik, we are reserving our comments on that. You file your affidavit. Enagali cousin. Before the next date of listing, a detailed affidavit on behalf of the respondents be brought on record. Also, the said affidavit must deal with the issue as to why the posts available, vacant posts available, posts of headmaster available in the district of Hailakandi has not been included in the process of recruitment, which in the process of recruitment by construing the procedure laid down in the said rules of 2018 for filling up of the vacant posts of headmaster. We'll see, don't worry. Because in that exercise, in that list, you don't have the liberty. Every year, this exercise has to be
Yes,
written.
that's
And how can you continue with the process of 2023? And Mr. Islam, Mr. Khan, you examine. I think 23 vacancies cannot be now filled up in this exercise.
2020.
It will be a fresh exercise altogether. You come up with that, please. We'll see.
Bless.
Pleadings complete.
It is complete. They are having the next meeting on 19th of this March regarding this supervisor appointment and pre-submission seminar.
So will your case be considered there?
My lord, that every day they are changing the stand. Today I'll show to your lordship provided she's going to make some submission probably.
Your Lordship, Mr. SCKL will make a submission in this matter. Kindly take up the matter after some time, Your Lordship.
We are sorry. Every day we have to keep a matter pending till the end. We are
Your
not.
Lordship is appearing before the Aizawl bench through video conferencing now, Your Lordship.
Maybe he will.
All along she
do
was
maybe-
appearing also.
Huh?
After all this days she was appearing.
Yes.
My lord, please take my this affidavit. Lordship will get everything in this affidavit. That starts from page number 147. 147. Lordship has got it, my lord. Please come to your lordship's order dated, page 163. Just 2-3 things I'll show. Every coming days they change the stand. Total vault face or a somersault the respondent already is making. My lord, kindly see on page 164, second paragraph. Lordship knows, my lord, in the ordinance as well as in the regulation, there is no provision for consent to be given by a scholar for appointment supervisor because it is inbuilt in their institution, my lord.
That is for the institution
Exactly,
to decide.
exactly. That's what. Now, page 64, kindly see. When the honorable court asked me, my lord, Mr. Nath, why don't you give on consent? Let me sort it out. I said, done, my
You
lord.
have given.
Yes, I have given. Now, kindly see what I've given, page 165. Now, in this page 164, kindly see the last paragraph, kindly read, my lord, important. Having regard to the above projection and the submissions that Petitioner is agreeable for no objection. Lordship has seen. Now please come to the next page, 165. Please, 165. I have given to 12. With reference to the subject side above, I beg to inform that I have no objection for appointment. The moment I wrote no objection, there's a, kindly see the next page, 116, 166. Kind bottom. This is from the respondent number 8, Ajita Tewari, HOD. Kindly go through 173rd EC communication that was shared with you. Accordingly, you are requested to provide consent instead of an NOC. Clearly specifying the name of the faculty member under whom you wish to continue your PhD work. My lord, new one something. Now, next page.
Just a moment.
Suddenly a name came. I should give the name of the supervisor so that they can appoint, my lord. Something very new, out of the ordinance and the regulation. Because Honorable Court also said, give NOC. I gave it. They said, no, not NOC. Give no consent. You give consent along with the name of the supervisor, my lord. Then I have written to them, my lord, on the next page, 167. I have contacted my fellow research scholars to get copy of the consent email, my lord. This is the third paragraph. Sent to you on or before 35/25. One of my fellow research scholars has shared her email and I have gone to the same content in email.
So now you give your no objection as well as your consent.
Consent I have given.
Then
now they say, no. You give your consent along with the name of the scholar. Page number 166. Supervisor.
168.
166, bottom. 166, bottom.
Then you give that.
I gave no consent. Then I wrote that fellow research scholars only given their name, not the consent, not the names. That's what I have written, my lord. Then again, no, next 168, kindly see. This is the example I have given. That Florence, that's the, my lord, co-scholar. She has given only the consent, not name. But the lady R8 is repeatedly insisting I should give the name. Then, my lord, on 171 page number, my lord. This is what, my lord. They said, second paragraph, last line. She also submits, my learned friend. As per instruction received by her, petition is going to be allotted supervisor, co-supervisor. On the other hand, such and such. This is extension is due expire on 23/160, whereas respondent authorities are contemplating to convene meeting on 28/176. Considering the instruction received from the respondent university, since the meeting cannot be conducted despite receipt of the NOC from the petitioner before expiry of the term, it is made clear that respondent university shall not reject claim of the petition on the ground of expiry of the extended time period. Now, finally, see 175 page number. Your lordship's order, my lord. This lordship can see from second paragraph. The submitted that university authorities in a meeting convened on 28/126 had allotted Dr. Avinash Kumar as the supervisor of the petitioner. Accordingly, the grievance of the petitioner with regard to allotment of the supervisor to him for conduct of PhD course is redressed. No problem. It means they submit that she has received an oral instructions from the respondent that an extension has been granted to the petitioner for completion of his PhD course. Now there will be, lordship will find there is a somersault. Coming to it. Third and such, they shall receive instruction university authorities to issue appropriate communication in this connection to the petitioner. Next, it is submitted without scheduling the said pre-scheduling seminar. Petitioner would not be in a position to submit the thesis, inasmuch as the petitioner has already completed research work. The above instruction be furnished by this court on such a next date of hearing. Next, my lord, kindly see what they've done next day. The next day, what they did, there's a communication, my lord, kindly see page 180. They have furnished me this communication, 7th of February. And before that, 6th of February, there's a order by this court, scheduling page seminar, my lord, list them. Kindly see next 180 page number, 7th February. Third, 1, 2, 3, 4th paragraph. As per provisions of PhD, this is very important.
Where?
Page number 180.
180,
Yes. Para 1, 2, 3, 4. Fourth paragraph. Further.
1,
Start
2,
from.
3, 4. Further.
Yeah, further. As per provisions of the PhD ordinance, you are also directed to uphold all research advisory committee reports in the online PhD portal without fail. It is mandatory. Now, my lord, I vehemently oppose. I said in the ordinance, this is inbuilt inside report of the university. How can I get RSC report? Where is the provision in the, my lord, ordinance also? I should upload. When I said that, my lord, honorable court has pleased to pass that order. Kindly see that order. I have written in detail is in page 182, saying how can it be? This is your document, inside document, RSC reports. Research Advisory Committee reports. I cannot hold these reports, my lord. In our portal also, doesn't say the ordinance. I'll show to the regulations, my lord. Then I wrote in page 182, details I have written, my lord, the procedure, how it is done, when the division was taken. Then page 187, my lord.
Just a moment.
Yes. This is important. Online portal upload all the research advisory committee reports. Now they will say that
Now 182.
Yes, now kindly see 182, that means my representations. Details I have written, my lord.
What is the vital one here?
Yeah. 185, now page number kindly see, Honorable Court Order 187. This is important here. From there, they have changed the stand once again. Since PUPI, the Learning Council appearing on behalf of the SCKL, Learning Studying Council of the Assam University, strenuously submit that petitioner is required to upload all the research advisory committee report to on the online PhD portal, which is mandatory for further academic processing. She is granted 1 week's time to file an affidavit explaining why documents, particularly the research advisory committee report, are required to be mandatorily submitted by the petitioner in terms of PhD. Yeah, I insisted, my lord. Let me showing the ordinance, my lord.
Okay, where is the affidavit in?
I'm just showing, my lord. The next day, they did not file the affidavit. Lordship asked them, they will appear personally, they don't file. Now, please come to, my lord, page number, it's 122. Page number 122, their affidavit. Para 4.7.
This is the affidavit in pursuance to that.
Yes,
order.
yes. Once your lordship is that they shall appear before the court. If they don't file the affidavit, then next day, my lord, they file it. Page 122, paragraph 4.7. See, there is the board face now, my lord. Absolutely, my lord. Reverse stand they have taken now. 4.7. No whisper of RAC report now. That the deponent begs to state that, as per Honorable Court's direction, the petitioner has submitted his NOC for which the matter was raised before the DRC, and the DRC in its meeting dated 20th January 26 appointed Dr. Abhinesh Kumar as supervisor. Answering deponent would like to further state that after allotment of supervisor, petitioner need to upload all necessary report and supporting documents in online portal through his supervisor as per PhD or regulation. But you have seen, my lord, that letter, all RAC report as per ordinance. When I challenged, I said this cannot be. The Honorable Court, that's why passed an order. For it, filed the affidavit showing under which ordinance it is being. Now they change the stand. Now they say all necessary report. Where has gone the RAC reports? Under which ordinance? Let me show that. There's nothing. Total change of stand, my lord. Like that. Now, my lord, they are going to hold them. Then let me read next.
No, complete this.
Yes. Then his application for extension shall be placed through proper process before the Board of Research Studies for final approval. BRS meeting scheduled to be held on 19th March as per such and such. Be it important to note that after registration gets approved by the BRS, only the petitioner will be able to process for pre-submission. Matter is already communicated to the petitioner by respondent number such and such, my lord. Now they are putting blame on me. Why there is a delay on my part for my lord.
No, what is this requirement that they are doing?
Please come to page number, my lord, 54
50.
of my petition. It starts from page number.
What is this RAC?
Research Advisory Committee. Page 51, kindly see, my lord, Research Advisory Committee. Lordship will find it there. And their function also.
Page 50.
Page number 51. Clause 8. Research Advisory Committee and its function. There's
Now, going through this, Mr. Nat, I never had an opportunity even to apply for PhD. But now I feel that I am a PhD student now.
Same with me. Same with me, my lord. When I
Yes.
got this case, my lord, I was enjoying it. This is a subject I knew.
Enjoying, right?
Yes. There shall be a 5-member research advisory committee for AM
Where? Page 51.
51. Bottom 8, seal number 8.
There shall be.
The 5-member committee, my lord.
Hmm.
For each scholar, the committee shall be notified by head of the concerned department immediately after admission of the scholar in such and such. RAC shall consist of head of the department, 1 teacher and such. Next page, my lord. This is not important there. 8.3, meetings of the RAC shall be notified such and such. 8.4, to committee shall have the following responsibilities: to review the research proposal and finalize the topic for research.
This is done.
Yes. Now, my lord, 8.5, every research scholar must appear before the RAC once in 6 months. That is, 6 monthly, whatever progress they made, they must report to the RAC, my lord. That's what. Next is serial number 9. That's important. We got stuck up here now. Research Advisory Committee and its function. The DRC shall be constituted for each academic department offering MPhil and PhD program. All teachers of the department eligible to supervise all the members shall be members of the committee. One member shall be opted from another department of the same school of studies. Another member from the such. Next page, my lord, serial number 9.2 and 9.2.2 is important. DRC shall look after the following research-related matters. Here it comes. Conducting the personal interview during MPhil PhD degree. 9.2.2, assigning supervisor to attend selected candidate. Lordship has seen, where is the question of consent? Even, no here Lordship will get it. Evaluation. 10.2, can you see? Upon satisfactory completion of the coursework, obtaining the required mark grade, scholars shall be required to undertake research work, such as discussion. This everything has been done. Now, so what the selection of supervisor is concerned, that has been done, my lord. Now, page 54.
10.4.
10.4. What RIC does, my lord? Prior to the submission of the dissertation of the thesis, scholar shall make a presentation in the department before his RIC, which shall always be open to all faculty members and other research scholars. The feedback and components obtained from them may be suitably incorporated in the draft dissertation thesis in consult with the RIC. Next, scholars shall be allowed to deliver pre-submission seminar after completion of at least 2.5 years. Such. That means, my lord, period initially 6 years. You can do the PhD. Suppose you cannot complete, you get 1 year extension with application. Suppose you cannot complete, there are still circumstances you can apply. Today period 8 years. Minimum period is 2.5 years. You can do it. Because I know one of my client, my lord, this case is pending here, his mother's case is here. He went to USA, my lord, California University. From Delhi, engineering he was doing. He was given a 5 years course, my lord, for PhD in engineering. And he's doing with the, my lord, art material. This boy from Jorhat, what he has done, my lord, he stood second in the world. What he did in 9 months, completed the course. And now, last around 6-7 months, he's been appointed as assistant professor in California University. My student, my lord. And his name, everything.
Value the talent.
Talents. And he's dealing with art, my lord, materials. Your lordship knows that nowadays that all the question about they are art material. The subject is this now. Now, various companies coming to his mother told me, various companies coming to offering huge amount of money. He said, no. This university has given me starting in my life. I'll not leave university, I'll be here. He stick to that in California University, my lord. This boy, my lord. His name came in the paper and he was felicitated in Jorhat last year.
It's a great.
This is what, my lord, minimum. He did in 9 months, my lord, 5 years course.
Now you have completed?
I have completed. Now 6 years gone. Then I paid for 1 year because there was a COVID.
Where is the extension thing?
Extension is, my lord, you will find page number 91. Page 91. In persons of the ordinance of MPhil such and such, as per the resolution around 10-15 meeting.
This is your first extension.
Serial number, yes. Serial number 1.
After 6 years.
Yes,
after
6
5
years.
years.
Yes, after 6 years. 21-19 to 23-1-2026. Now the question arose. When I wrote to them, after the consent was around in the month of May, then they are doing nothing. In the December 9th, I wrote to them, please allow me to hold the seminar. If they have allowed me to hold the pre-submission seminar, I could have done it next week, any day before this completion of date. I could have submitted my lord even PhD thesis also. They said about the matter.
Pre-seminar before the DRC.
Yeah, pre-seminar before the RAC.
RAC.
It's RAC, pre-seminar. I wrote to 9th, my lord, lordship will find it here in my petition. 9th, page number 106, my application can see. Now they are coming and saying, my lord, no, you did not apply 3 months prior to expiry, so we cannot give you. No, that's not the case here. It is they held up my process, my lord. 106, my application. I wrote to them, my lord.
Yes,
Chairperson.
madam, what is this happening?
Your Lordship, if Your Lordship may look at page 116 of our affidavit in opposition, Your Lordship. The situation as such was the original supervisor, Your Lordship, of the petitioner, Professor Ellen Sethi, was suspended, Your Lordship.
In 22.
Yes. After
Those
that,
are old stories. We know that.
Yes.
yes,
He
Your
has
Lordship.
been given a new supervisor.
Yes, Your Lordship.
Now his thesis is practically complete.
Yes, Your Lordship.
Now you first asked him, give us the PRC reports.
Yeah.
PRC reports are something which you
RAC report, RAC.
RAC reports, which is something which you will have, not he. Now, why are you not allowing him to go forward?
Change the stand next day now, my lord.
Now you say that you give us this your complete papers, this, that, those are not the original stand. And why is his extension not being considered?
If your lordship may have a look at page number 138, your lordship, of our affidavit in opposition. Point number 13, your lordship, pre-submission clause.
130?
8.
That is page number 63 of my petition. I relate on that.
If I may read it, your lordship, an application in plain paper is to be submitted by the scholar to the supervisor for requesting of pre-submission seminar after completing at least 2.5 years from the date of submission in case of PhD and 10 months so and so, your lordship.
But he has already taken us.
Your lordship, he needs to submit it to his supervisor, your lordship, and the supervisor needs to communicate it to the department, your lordship. He cannot directly submit it to the department, your lordship.
Mr. Not, your client is there.
Yes,
Ask him to submit that to the supervisor now, today, by 2.
by 2, my
By
lord.
2.
My lord, I'll ask him.
And
He's in Gauhati, he has fractured hand, but by email he'll do it. He's doing it through email. My
ask
lord.
his supervisor to place it before the committee today itself. So that on
He should write in the petition. He should.
he should, because she says,
Yes.
her objection is
Yes,
that he should apply through his supervisor.
my lord.
And you have applied directly.
Yes.
Madam, are you sure that is your submission?
Lordship, it's mentioned in
Okay, we do one thing. Mr. Nutt
My lord,
will not put a young girl to trouble. Let Mr. KL come.
my lord. My-
Immediately ask him when he is free to come. Inform Mr. Nutt, both of them come. Please inform. We'll
And I am in the meantime, I'll ask him to apply.
no, don't do
All
that.
right, my lord.
Because that
Fine,
is her
fine,
permission.
fine.
I don't want
Okay,
to
okay, it's all right.
put
it's
it
all
in her mouth.
right. She's doing well, my lord. As a general, she's doing
But I
very
don't
well.
want to have
I
this-
congratulate her. She's doing very well.
that's why I did
These
not
are
allow her
for
to
that.
get an adjournment,
I
because
told
I
you.
am
Yes, yes.
confident on it.
Right, right,
But
right.
thing is
Absolutely.
that this issues may be too serious for her. It may
Yes,
be
yes,
not
yes.
proper.
Yes, that's true. That's
Let
true.
the
I feel it.
proper counsel who is there, let him come,
Exactly. Send her
so
to
that
the.
we can pass some. I don't want to put it in a.
Exactly, my lord, my lord, my lord, my lord, my lord.
Much obliged, your lordship.
But madam, this is what is going to happen.
Yes, your lordship.
Now I think you are going overboard. And we will ensure that on 19th, his case is considered.
Yes, your lordship.
Ask Mr. Cal to have all requisite instructions for that purpose. Yes.
Obliged.
Mr. Nutt, you can have a cup of tea. When Mr. Cal is free, he'll call you, come down, both of you inform.
My lord, I'm so obliged, my lord. She can continue.
Madam, may please inform the senior. Yes, done.
We have, I have received the instruction and we could not provide the information to the department because there is a lapse in the financial system of the bank. So it needs some time.
Mr. A. Parvez, Standing Counsel, Punjab National Bank, has submitted that the system wherefrom the information with regard to the drawal of pension and pensionary pension by the petitioner is to be prepared is not functioning, is not accessible for some software. issues.
Software problem.
He submits that the matter is being now matter is now being considered and would be resolved in a few days.
Yeah, yes,
Accordingly, he prays that he be granted further 10 days time,
2 weeks time maybe given.
2 weeks time to place on record the drawal statement of the pension drawal statement of the petitioner. While Mr. Parvez on the next date of listing shall place on record the drawal statement as a drawal statement of the pension and pension by the petitioner, comma, a statement in this connection immediately on the application becoming accessible be forwarded to the jurisdictional treasury officer, who shall thereafter forward the same to the Director of Pension for further necessary action. Registry to list this matter again on 27/3/2026.
Right.
Yes.
Well, here direction was given us to bring the status regarding submission his application. Well, I have not received that.
Why? This was passed long back,
True, in the year 2024.
24 itself.
My lord.
Huh?
My lord.
Why?
Some time may be granted, my lord.
Time, okay, 2 o'clock.
Sorry. My lord. I'll try to do. Bless.
Just for time being, can you raise another?
None appears for the petition on call. Mr. U. Sharma, learned standing counsel, Secondary Education Department is present. The present writ petition was instituted by the petitioner, assailing the selection and appointment of the respondent number 5 as the principal of Puri Nagar Junior College. Also, this court finds that the petitioner in the matter had already retired from her services on reaching the age of superannuation in the year 2018 itself. Also, it is a settled position of law that after superannuation, the prayer for promotion with retrospective effect would not be mandated to be so considered, more so when the rules holding the field also do not provide for such, do not make any provision for a retrospective promotion in respect of a retired employee. Full stop. In view of the, however, in view of the fact that there is no one representing the petitioner today, as well as it is found that there was no representation on behalf of the petitioner on the last date of listing, that is on 28/3/2025, the present writ petition is dismissed for non-prosecution. What is the status of the school today?
But our case is that in view of the office memorandum, our case, our school cannot be amalgamated.
But it was that time. Now it's not a madrasa.
No,
Now it is
madrasa,
not a madrasa.
madrasa and high school, there is no difference.
No, madrasa is gone. Now it's a school. So it will be covered by that office memorandum subsequently.
Our is the madrasa and it has been amalgamated with high madrasa.
It is no longer a madrasa now.
High school.
It's no longer a madrasa now.
But my lord, if your lordship kindly see the office memorandum, that lordship may kindly see page 20.
Page 20.
20.
Type copy.
Here, the department is receiving various proposals for amalgamation of different categories of schools located in the same campus, which are still pending due to absence of clear policy in this state, in this regards. It has been found that there are many common campuses where different categories of school higher secondary school, high school, ME school, and even LP school also exists in the same campus. So same campus word is always there. But our school is not in the same campus. And over and above, Lordship may kindly see page 2-4.
My lord, in this matter, our name has not been shown in the course list, my lord. So we have missed it.
Hmm?
Just as J Assam is shown here in the course list. Not secondary education.
Page 24, Lordship would see, para 10. If a ME school has.
Do you have you don't have a file also of this? Don't have file.
Today, we have actually missed the file because our name is not shown here.
Heard Mr. M.U. Mahmood, Learned Counsel for the petitioner. Mr. U. Sharma, Learned Counsel for the Learned Standing Counsel, Secondary Education Department has submitted that as the name of the Standing Counsel, Secondary Education has not been reflected in the cost title. They have missed the present writ petition. So,
But our name may be shown in the course list here, my lord.
this court finds that the Standing Counsel, Secondary Education Department had received notice in the matter on 16/2/2018. Thereafter, on 25/4/2018, the Standing Counsel Elementary Education Department had prayed for 2 weeks' time to file an affidavit. This court-wide order dated 13/5/2020 had required the registry to list the matter on 15/5/2020, reflecting the name of the Standing Counsel Education Department. In spite of the set position, it is found that the matter has been listed by the registry without reflecting the name of the Standing Counsel, Secondary Counsel, Department of School Education, the Standing Counsel, Secondary Education, Elementary Education. So accordingly, registry is directed to list this matter again on 17/3/2026, 19/3/2026, reflecting the name of the Standing Counsel, Elementary Education Department and Standing Counsel, Secondary Education Department. Anything more is required? Mr. Sharma, on that day, we'll close the matter. You have instructions or don't have instructions, we are not waiting for that.
My lord, in this matter, elementary also party here, my
So
lord.
I have asked both.
Yes.
My lord, I may be permitted to obtain instruction in this matter from their respective schools. It's a case of draft post teachers.
No, when was the school provincialized?
That I cannot say at this moment. My lord.
Then there is nothing here. We are dismissing the petition.
No, I have to obtain instruction in this matter.
What instructions?
With regard to the present status of the case.
We are not concerned. What prevented you? 18 matter, we are not keeping it. When was your school provincialized? Mr. Fukon,
Hello.
please have your seat. Because you are not in a position to make any submissions. You don't have any instructions. Please.
So I have to obtain instruction.
Huh?
Hello.
Are you in a position to make submissions here?
The moment, no, madam.
Then the moment, no,
On the last occasion, he was
matter is pending from 2018.
My lord.
It is
And
left
you
over.
people have not been able to even get a written instruction from your clients.
Last occasion, my lord,
Leftover.
they were asked to bring also, my lord,
That was left over.
Yes.
before that, my lord. They were asked one occasion, they were asked to bring.
So Lordship may
Regarding
kindly give me a chance to
It is-
obtain instruction in this matter.
What is your case?
Cases regarding drop teachers.
When was the school provincialized? The counsel,
Yes, sir.
this is not the way you argue. You complete your instructions by 2, otherwise I'm dismissing it.
Well, Lordship may fix it after 1 5.
10,000 cost.
Cost is a different issue, but obtaining is
This show I'm passing it. When do you want it? Give me a date of your choice.
next week. Madam.
Next week. 10,000.
What?
10,000.
Only for fixing a date, I have to pay.
No, yes, you have taken an adjournment. You have taken this adjournment on many occasions.
Not.
Yes,
the
you
matter
have,
not
Mr.
listed.
Counsel.
No, my lord. Lordship
And
may
if you
kindly
had any
proceed.
problem, you could have circulated a memo yesterday. We have read the file and come.
No, my lord, it is, we have no correspondence since.
Then forget it. We'll pass orders of whatever is required to be
At
passed.
least, at least obtain instruction, my lord. This is.
You have been obtaining instruction for the last 3 dates.
How it
Yes,
was not listed earlier. My lord. And
2 o'clock. If you want, come with your instructions or we are dismissing it.
because there is no correspondence.
Mr. Paul, I can't help it.
There is
can't help it.
contact number also.
Then what will you do? Taking a adjournment?
I have to pass a written instruction, my lord, from the.
What
concerned
prevented you from
If your
doing it?
lordship would permit me to do.
What prevented you from doing it till now?
No, some time may be given. because
I'm giving you time
Today,
till 2 o'clock.
today, no, 2 o'clock is very impossible today.
Then we are passing orders. You have nothing to submit.
I have to submit, my lord.
Then submit.
It is your lordship to give opportunity to hear me.
You submit. What you have to submit? When was the school provincialized? Seems you don't have a file also.
Yes, my lord.
Then. And the matter is lying here from 2018.
Yes. The case of particular drop post, my lord. Many.
When was the school provincialized, mister? That thereafter only the drop post would come. I have not found the date anywhere in the writ petition.
That's why I'm praying for obtaining instruction. I have to go through it.
Why did you file this writ petition then? Wastage of time of this
18.
court.
18, my lord.
You filed it. That date is not there. How will I construe whether you are a honorary teacher, whether you are a drop teacher, whether you have been appointed after the school was provincialized? Just show me that date of school when it was provincialized. That's all. When was the school provincialized? You also don't know.
I'm paying for the first time, madam.
First time.
My lord, come after a long time, but on the last occasion, if lordship says, my lord, they were asked to bring instructions regarding the, my lord, obtain instructions, my lord.
There is no such order.
Last date also, my lord, he had taken time, my lord.
No, I have not appeared. Leftover matter.
It's a leftover matter last time. What is the name of the school? That also you don't know.
Haradatta ME school, man.
Mr. Fukon, at 2 p.m. I want the instruction as to when the school was provincialized.
Departmental proceeding, my lord, of a university engineer, Dibrugarh University engineer. My lord, last order, if lordship see, my lord, last order. Yes, paid by learned counsel for the party leads the matter on such and such. It seems, my lord, we've just made a PR. 1 hour, 15 minutes, I made my submissions.
It was
Then
substantially hard.
hard. Then I'm not on that.
No.
Then what happened? Time was short, my lord.
Okay.
It's not court's fault.
It is submitted that the matter was argued on 24/2/2026 at length before a coordinate bench of this court. So, as prayed for by the learned counsel for the parties, a registry to list this matter before the court, which had heard the matter on 24/2/2026.
Will a roster, my lord will be here or not that day?
Whenever
Is there?
registry will place.
That I have, when you have made that plan, raised, it is it is submitted by the learned council.
Man, if your lordship takes up, I have got no objection.
No, it is submitted by the learned council for the parties that the matter was heard at length on 24/2/2026 by a coordinate bench of this court. Registry to examine the matter and list the matter before the appropriate court as and when the said bench is available.
But only one thing. When I made a request to keep it part-hard, Honorable Court didn't keep it part-hard because of the roster. So there is no feelings on the part of the court also. The court will hear the same matter again.
Actually,
So lordship will, so lordship even can hear the matter, my lord, in that case.
why again?
No,
1.5
no,
hours
no,
of court.
no, I'm just lazy.
No, I have asked the registry. Registry will take it up with the court. If doesn't do, comes back, I'll do it. No problem. But once when you say the court has invested time,
Yes, yes.
I think it's up to
1 hour 50 minutes. My learned friend was there. But my tea has got cold, my lord.
That is Mr. Gugui. He'll offer you.
He will provide, lordship. Along both of us, lordship.
No, the senior should be provided. Senior cannot provide.
Lordship.
Senior should be provided.
Lordship.
Yes.
Lordship, in this matter, we have not received our instructions regarding as to Lordship's query.
Why?
Just the thing is that a meeting was conducted and the certain allegations were found in that meeting and
It is submitted by Mr. I'm staying in.
Lordship, but if I remember right, on the first occasion when the matter had been reached before your Lordship, Lordship had stated that the speaking order which was issued against the petitioner.
Sorry, that is the final order we'll pass.
Lordship.
Heard Ms. M. Deb, learned counsel for the petitioner. Also heard Mr. M. Bhuya, learned counsel appearing for the
It would be
Health and Family Welfare Department. Health and Family Welfare Department. Also heard Ms. K. Fuka, learned government advocate at government advocate. Also, government advocate to Agotaki. The petitioner has instituted the present petition, assailing a speaking order dated 4/2/2026, by which basing on certain allegations brought against the petitioner in his capacity as an internal examiner for the subject of orthodontics in the 4th BDS University examination held in November 2025, inter alia. The petitioner was barred from all university examination duties and responsibilities for a period of 5 years with immediate effect. But for the registrar, Simanto Sankodev University of Health Sciences, had passed the following order. Para 5 A to A. Also, this court on 18/2/2026 had directed the learned counsel representing the Srimanto Sankardev University to complete his instructions in the matter and had directed for listing of the matter on 9/3/2026. On 9/3/2026, when the matter was listed, the learned counsel appearing for the respondents had sought for further adjournment, which was also granted by this court, and the matter was directed to be listed today. Today, when the matter is listed, Mr. M. Bhuya, learned counsel, appearing for the You are appearing for the university also?
Lordship, may I actually record Mr. B. Gugu's name?
He's not here.
Lordship, but he's on legs, Lordship, that's one.
Not here.
Then in that case, it's okay.
Oh, you get Mr. B. Gugui. We'll pass the orders.
Lordship.
let Mr. Bigugoi come. We are staying that only to the extent of your debarring.
Lordship, if I remember right, subject to your Lordship's convenience.
That opportunity is gone. Now we will
Lordship.
say it on merits.
Lordship.
That madam has also objected. Now we'll see it on merits. Let Mr. Gogoi come. We'll see. Get hold of madam also before
Lordship,
Mr.
Lordship,
Gogoi
Lordship.
comes. Inform her. Both
Lordship.
come together.
Lordship.
Wait for some time. Have a cup of tea or something special has come from home. Have
No,
a-
Lordship. That is it. Could not prepared.
Oh.
Must be like.
Yes, Mr. Nat.
Matter is relating to non-payment of salary of certain period. So, my lord, is supposed to be just for referring to the mediation.
Want to go?
Want to go, my lord.
Hey, mediation or similar order might be. Date ta fix koi dibi. Aru Joydev Kushor number kita ase na similar order ase to. We'll fix a date and send it.
Published.
Date na di diya hai. Bihu pisot.
Hey, maybe after.
Na bihur agot diyo. 28. 1-4.
Published.
Ase na kiba kiba disu to. Hey, Ranu ta to thali. Yes, Mr.
And all the petitioner was proceeded departmentally and issued a show cause notice, which my lord will find at Annexure C. He was placed under suspension before the issuance of the show cause notice. Allegation being demand and acceptance of bribe amount of rupees 5,000. Lord, thereafter, my lord, an inquiry committee was constituted. And a report was submitted by the inquiry officer, but no specific findings on the guilt of the petitioner. But no findings, my lord. There were no findings. Okay, my lord will find the inquiry report at page 29, Annexure G. The conclusions drawn by the inquiry officer, which my lord will find at page 31. My lord will find that there are no specific findings. The latter part of the.
Where is your penalty?
The penalty has not been imposed, my lord. That is one of my contentions.
There is a
The
restraint
inquiry
order.
report was submitted, but
There is a restraint order.
My lord,
There is a stay.
there is a stay.
Where is that stay?
But there will be no coercive action.
Okay. Why this proceeding should not be taken to its logical conclusion?
My lord, on principally primarily on one ground, my lord, that the.
What happened to the criminal case?
The criminal case is just, the trial is just started, my lord.
So that this cannot be a bar.
But
This is already concluded.
But my lord.
You have disclosed your hands.
That is true. my lord.
What
That is true, my lord.
more is there?
At my prejudice, my lord, I have.
That cannot be held. This is the only thing that the department proceeding can be pulled back.
My lord, true, my
So
lord.
that you don't disclose your hand. You have already disclosed your hand.
Yes.
So that we will ask them to proceed with the matter, reach a conclusion.
And my lord, there is another aspect to the whole thing, my lord. The fact that he's been in continued suspension since 2023.
That is not under challenge before us.
But
what
I
we
have
have
also-
challenged is only the
Departmental proceedings.
that suspension will continue. We will not interfere.
But at least, my lord, in view of the fact that the representation has been made,
Where is your prayer to that effect?
the prayers.
This is only the inquiry report.
My lord.
We'll ask them to take it to its logical conclusion. You have submitted your reply also.
Yes, my lord.
We'll ask them within a period of 3 months to complete this process. That's all.
My lord, an observation that he has been under suspension since 2023.
That is not called for now, because the proceeding has come to an end. And it is because of your thing coming here and asking for no coercive action that you have been prolonged suspension.
But even before that, my lord.
That you have not challenged. Any suspension order on the road, this court is not called upon to interfere under Ajoy Chaudhary. Something should come before me, then only I'll interfere.
My lord, I am treading on very slippery slope, my lord. But an observation
You
also
had
would help.
got enough relief in this. I think now it's time to give it a closure. But let us see how your friends on the other side will help you.
My lord.
Please have a seat. Yes, Mr. Sharma.
My lord, here it is, my lord, a report of inquiry, and it is page 31. Last line conclusion. It was found in the inquiry that he accepted rupees 5,000
Okay, accepted.
from the complainant, base, so and so on 6/4/2023, and at the moment, the team of vigilance and anti-corruption apprehended Mohammed Anwar.
I got it.
Yes.
But why have you permitted this interim order to continue till now?
The lapse. No, it was a lapse of in our part, my lord.
Okay. Heard Mr. T.N. Srinivasan, Learned Counsel for the petition.
Yeah, my lord. That is my representation where I have sought for reinstatement. My representation is.
We are asking them to complete the departmental proceeding and pass appropriate orders. If you are not imposed with a penalty of dismissal, removal, or compulsory retirement, you are automatically coming back. Heard Mr. T.N. Srinivasan, Learned Counsel for the petitioner. Also heard Mr. U. Sharma, Learned Standing Counsel, Elementary Education, Secondary Education Department. Appearing for the respond number 1, 2, and 3. None has appeared for the respond number 4 and 5. The petitioner in the present proceeding has presented a challenge to a show cause notice dated 13/7/2023, as well as the inquiry report submitted thereon by the inquiry officer on 2/8/2023. Also, the petitioner in the present petition was arrested by the Vigilance and Anti-Corruption Branch from Assam in connection with ACB PS case number 27/2023 under Section 7 bracketed A of the Prevention of Corruption Act 1988 bracket as amended in the year 2018 bracket over. So the allegation against the petitioner was that the charge against the allegation against the petitioner in the said police case was that he had demanded and accepted a bribe of rupees 5,000 from the informant therein. So the petitioner being placed under suspension, placed under arrest, and he having remained behind the bars for more than 48 hours, the Inspector of Schools, Sonitpur District Circle, Tezpur, proceeded to place the petitioner under suspension. Also, at the first line, the petitioner, while serving as a lower division assistant, bracket, presently junior assistant, bracket over, in F.A. Ahmed High School, Bishwanath Ghat, was arrested by the placing him under suspension. Also, thereafter, wide an order dated wide a show cause notice dated 13/7/2023, the petitioner was issued wide a show cause notice dated 13/7/2023, a departmental proceeding was instituted against the petitioner hearing. The petitioner is found to have submitted his written statement against the said show cause notice, on 27/2023. Thereafter, the FUSA, being not satisfied with the pleas taken by the petitioner in his written statement, the disciplinary authority of the petitioner proceeded to direct for holding of an inquiry in the matter, and accordingly, an inquiry committee consisting of directed for holding of an inquiry in the matter, and accordingly an inquiry officer and a presenting officer came to be appointed in the matter. Also, the inquiry officer, on conclusion of the inquiry, proceeded to submit his report on June 8, 2023. A copy of the said inquiry report was also furnished to the petitioner hearing. Also, the petitioner, on receipt of the said inquiry report, had submitted his representation thereto. Also, however, no final orders came to be passed in the matter by the disciplinary authority. Also, after submission of his representation in the matter against the said inquiry report dated 2/8/2023, the petitioner had instituted the present proceeding. Also, the petitioner in the present proceeding had alleged that the inquiry was not conducted in the manner as required. Further, it was projected that the inquiry officer had not returned his finding with regard to each of the charges framed against the petitioner. Also, the petitioner had also alleged that he was not given an opportunity to cross-examine the witnesses. Also, the representation submitted by the petitioner against the inquiry report was also brought on record in the writ petition as Annex H thereto. Also, this court-wide order dated 10/5/2024, while issuing notice in the present proceeding, was proceeded, while issuing notice in the matter, was also pleased to pass a direction that no coercive action shall be taken against the petitioner till the next returnable date. This court has examined the orders passed by this court subsequent to 10/5/2024 and finds that the order that the direction for not taking any coercive action against the petitioner was not continued with. Also, accordingly, the said direction has to be held to have lapsed after the matter was listed on 27/11/2024 and the said directions was not extended. Also, Although the interim directions have, the interim directions passed have not been extended, comma, this court has considered the projections made in the writ petition, which was also reiterated by Mr. T.N. Srinivasan, learned counsel for the petition. This court finds that the said projections made in the representation submitted against the inquiry report would now be required to be so examined by the disciplinary authority while considering the matter for passing of final orders with regard to the departmental proceedings instituted against the petitioner hearing. This court at this stage would not venture to draw conclusions with regard to the contentions raised by the petitioner, inasmuch as the said contentions would also remain open to the petitioner in the event a penalty is so imposed upon him, and the penalty is imposed upon him and the same is put to challenge either in an appeal and thereafter first in an appeal before the appellate authority and thereafter in an appropriate proceeding before this court. Also, in view of the above position and the disciplinary authority having not applied his mind to in the matter after receipt of the representation from the petitioner against the inquiry report submitted by the inquiry officer, this court requires the disciplinary authority to examine the inquiry report along with the materials brought on record by the inquiry officer, brought on record in the inquiry in the light of the contentions raised by the petitioner in the representation submitted by him against the inquiry report, and thereafter to pass final orders in the departmental proceeding instituted against the petitioner hearing. The said exercise be initiated and completed by the disciplinary authority within a period of 30 days from today. On the end of the 30 days, the disciplinary authority of the petitioner shall pass orders as would be so called for in the matter and communicate the same to the petitioner. Also, with the above, Mr. U. Sharma, learned counsel for the learned standing counsel, secondary education department, shall forward a downloaded copy of the present order to the disciplinary authority of the petitioner for compliance of the directions passed herein above. Also, with the above observations and directions, the present writ petition stands disposed of. Just make some small corrections. I've kept everything open, Mr. Freeman.
Yeah, please, Lord. My lord, the petitioner was earlier appointed as laboratory assistant, laboratory bearer, assistant cum bearer in in a high school, and thereafter he was appointed as LDA. That is page 18. Subsequently, he was promoted to the post of UDA on 5/3/1998, page 20. In that post, he was working. Thereafter, his post was reverted. That may be seen page 25.
Okay. Page 20 is your promotion order.
Yes. Thereafter, on 25, I was again reverted to the post of LDA. That may be seen page 25.
This order is 5/3/98.
Yes, the promotion order, yes, 5/3/98. And then he was reverted on 25/7/2008, page 25.
What is this writ petition you have filed?
My prayer in this writ petition is that
No, the earlier writ petition.
earlier writ petition was to consider their promotion, that is page 22.
That is earlier to 98. Yes.
Yes. Then
page 25.
yes,
What happened? You were
reverted. On the ground, kindly see the ground. In pursuance of the DSA ASAP's order number so-and-so, dated so-and-so, Sri Liaquat Ali Majumdar, UD assistant, who was reverted to the post of LDA, is hereby released today to enable him to join his duties as LDA assistant at Government EMSS School, Hailakandi. So he was reverted on the basis of DSC's order on 25/7/2008. Though he was reverted back to the post of LDA, but till the day of his retirement, which he retired on 13/12/19, he was working as UDA and had also drawn the salary and other allowances as
till when did you retire?
on 13/12/19.
13.
Yes, 13/12/19.
13, how can you retire on 13/1/3?
13/12/19.
You can't retire on 13. You will retire on 30th or 31st.
That is here. The Lordship may kindly see page 58. This is a principal's letter. On that day,
31/12.
31/12.
Ah.
31, yes. Typical mistake is there, so I'm sorry. So on that day, he went on retirement. But if your Lordship kindly go through the letter of the principal, page 55, here kindly see regarding resubmission of pension proposal in respect of Sri Liaquat Ali Majumdar, retired LDA, Government School, Hailakandi. Various letters have been quoted here. How he was appointed as laboratory bearer, then as LDA, then UDA, then again reverted back, but he was taken the service of UDA. That Lordship may kindly see page 57. Here, office of the PAG, A&E Assam, Moidang Beltala, Gauhati, fixed his basic pay of rupees 9,670 as LDA, but admitted that the incumbent promoted to UDA with effect from 1/4/93 and suggested the incumbent to get salary of UDA from the department, as is stated in lines number 11, 12 of first paragraph of PAG's letter number so-and-so, dated 3/2/22. Then Lordship would kindly come to page 58.
Where is the letter of the Accountant General?
Yes, that is, my lord, page 54. Your return of pension case in respect of Sri
Just a
Liaquat Ali Majumdar.
Just a moment.
So, last part may be.
Just give me a second, sir. Yes, Mr. Mohan.
Oh, my lord, the principal has given a detailed story about my services rendered as UDA. And the last part, lordship may kindly see page 58.
Have you finalized the PPO?
It was earlier finalized.
I've annexed in the affidavit of position.
It was earlier
This is
finalized.
finalized now in terms of the
LDA
LDA scale.
lordship.
What is the recovery?
Recovery, lordship.
18,50,000.
Yes, lordship.
That has been made.
Lordship.
No. It's not.
Lordship, it was, I think lordship need to be recovered. We have issued the order to the treasury lordship.
It's not.
You are getting your regular pension now?
How, my lord?
He's getting lordship.
My lord.
You are getting your regular
No, I am
as
getting
LDA.
lump sum amount.
Getting as
per
LDA
High
lordship.
Court order.
He's getting as LDA lordship.
You are getting your
LDA.
PPO is
But
issued.
thing is this, they cannot
Mr. Mahmood,
recover.
are you getting your
Yes, I am
pension
getting
now? Regular pension?
pension, not full pension, but some provisional pension has been paid.
No, final pension. We have
Getting
issued
your final pension. PPO has been.
page 94 lordship.
Page
94,
94.
95.
First,
With
what
the
they have
recovery
said-
of rupees 18,15,847.
No,
Yes,
so
what is your grievance in the report?
grievance is that, my lord, when I have rendered service as UDA, so they cannot recover my amount.
Show me that you were serving as an
Yes, I have
UDA
given the
after
citation.
25/7/2008.
I have given citation.
No, after 25/7/2008, you are serving as an UDA. Show me that.
But my service was taken as UDA.
Where? From where?
Yes, it's the headmaster's
The
letter.
headmaster's letter will not do. You joined a post of LDA.
Headmaster wrote the letter
You
to
were
the director
reverted.
as per his
That
requirement.
was an error. That error you cannot take benefit of.
No, it is Supreme Court also says that you cannot recover the amount when you have.
Show me that you were working as an LDA, a UDA. Just show me that. First, your statement in the petition. Just show me that.
Yes.
That after 25/3 also, you were working as UDA, not LDA. How can you work in a government institution?
That, of course, as per order, it cannot be done.
Then
But lordship may kindly see page 9, para 8. That the petitioner expressed that he always discharges his function
that
as
cannot
duty.
be because there is the order in between 25/7/2008.
Yes, that is true.
2008.
That is true. But thing is, this authority has taken my service as UDA.
Where?
And
From
the
where are
honorable-
you getting that?
Here, everything has been clarified.
Page 56, the principal says incumbent reverted as LDA.
Lordship, page
Kindly
25
page
also, lordship.
57, kindly see.
Annexure 5, page 25 also lordship. That is the order of the inspector of.
But that we have seen. Where is the order
Yes.
allowing you to work as UDA?
Page 57. I was working under the principal and principal allowed me
He
and
has got no
all
power.
along,
He has got no power, jurisdiction.
all along
Cannot.
power, all along till 31st December 2019, I was working as UDA and was drawing the salaries and allowances.
That is the mistake.
But for the mistake of the government, how these persons at the after retirement can suffer. So here the Honorable Supreme Court has said some, I have given the citations, only see they cannot recover. They cannot recover any amount. 2009, kindly.
What is the citation? What is the name of the case?
Case
Rafiq Mashid.
Soyed Abdul Qadir and others. Here, para 61 is relevant. Kindly see.
Yes, Mr. Who is appearing for the respondents?
Lordship.
Let me satisfy your
Lordship,
lordship on that point.
He was working.
I'm for the accountant general. lordship.
He was working. He was working, whether he is getting LDA, UDA, whatever it is. You have been giving him, but the respondents have been giving him. After his retirement, you detect that. They also prepare everything in the UDA scale of things. Now you reduce everything, no issue. Pay his pension as LDA. But why that recovery? That will be hit by Rafiq Mushik and the.
Lordship, that is to be dealt with by the administrative department, Lordship.
Yes,
We are the only
madam.
authorizing agency, Lordship. As per service book, Lordship, we have detected, Lordship.
Yes.
And Lordship, but
You
during the time of,
to pay him.
but Lordship, at the time of retirement, he has knowledge, Lordship, which post he is holding, Lordship.
He may have that point of time, but we cannot. Have you alleged that he was responsible for that? Have you alleged in your petition anywhere that it is the petitioner who had, who was responsible for this?
May I place the annexation? It's page 83. It's a report from the Lordship, where it has been stated that the petitioner was not allotted any UDA duties after being reverted on 25/7/2008. This is revealed in records in service book, page 2. So and so, it is mentioned that the petitioner was released and reverted to the post of LDA as per entry made by the then IS.
Then why was he authorized the UDA scale of pay? Continued to be authorized the UDA scale of
Lordship,
pay.
he was authorized, maybe he was authorized, Your Lordship, but he also had the knowledge, Your Lordship, because in Abdul Qadir, it is stated that Supreme Court has held, if a person has knowledge, Your Lordship, then
Impute that knowledge. You are now only presuming that he has knowledge. Now that knowledge has to be.
Because he was receiving the amount, Your Lordship, the salary.
He continued. He said that
He
maybe
continued.
government has reverted me, but government likes me, he's giving me. After retirement, you put that person to
Not sure.
the cross. That is not called for.
Because in
You have not said that he is responsible for continuing of that payment. You have not said that he was the one who made the fixation. Anything that connects him, tell me, I'm dismissing the report.
Because in Rafiq Masih, Your Lordship, the relief can be given only if it is seen that there was a misrepresentation on our part. Then it can be given.
But here there is no misrepresentation.
But then he is an LDA, Your Lordship. He had the knowledge. He should have.
Show me where you have taken that plea.
Lordship, in this we have.
No, tell me in your affidavit where you have taken
Affidavit
that.
we have not stated. It is.
You give him a clean sheet in the affidavit. You put everything on yourself and the AG.
Lordship, I'm just placing the law, Your Lordship.
No, law will come.
Lordship.
Law says misrepresentation, Mr. Misrepresentation and knowledge.
Knowledge, Your Lordship.
Just show me from your pleadings that that is there. It is only when the accountant general detected, it came to your notice. Till that time, you were very happy. And madam,
Lordship.
mind you, the first pension proposal was prepared by construing his pay at 51,000. Whereas it should have been 30,000. So that shows that you never had a objection.
Lordship.
If your officers can't detect that, can't help it. At this ripe old age, why put him to trouble? Yes, get the pension at the rate of the LDA. Recovery, we are interfering.
Lordship, let me obtain instructions, Your Lordship.
What instructions you?
Because why this was not the.
That should have been there in your affidavit. This is a matter of 24. You have out of the normal, what do you call that? Tide of the matter, you have filed an affidavit here.
We have filed here.
But the learned counsel for the parties at some length. Hearing
not
remains inconclusive.
Place one
This
thing, Your Lordship.
D. Mushahari is granted further. 2 weeks time to complete her instructions in the matter as to why the petitioner was continued to be paid his pay and allowances in the scale of pay authorized to the post of UDA, although with effect from 25/7/2008, he stood reverted to the post of LDA. She shall also apprise this court as to who is responsible for the non-fixation of the pay in the scale of UDA of the petition after he was reverted to the post of UDA with effect from 25/7/2008. Registered to list this matter again on 31/3/2026 for further hearing.
Obliged, your lordship.
Obliged.
Lordship, the Honorable Supreme Court is the order.
Stay order.
My lord, regarding the recognition of that university, my lord, that issue is pending before the Supreme Court, my lord. This is the.
That is a different issue altogether. We have been also adjourning, but I find that whether that's it's the distance education she had undergone,
My lord.
whether that university can offer course here, that's settled position of law.
My lord, that issue is pending, my lord, before the Supreme Court, my lord.
Okay. The learned counsel for the petitioner parties have submitted that the matter pending before the Honorable Supreme Court, which involves the issue raised in the present writ petition, has still not been disposed of. They submit that the matter be taken up, the present writ petition be listed after the disposal of this matter by the Honorable Supreme Court. So accordingly, registry is directed to list this matter again after 8 weeks on a date to be fixed by.
Obliged.
Anything to support my
Last the judgment. Lordship. Lordship, the judgment they have referred, Lordship. I think, Lordship, because the earlier judgment of 2005, that is not contradictory to each other.
Where are the judgments? It's not here. The judgment kita tata kumaya ase nahi. Agree. Judgment kita belegot kumaya ase. Itu case of item number 13. Second file to what's second file. That's not the simple. Kept the judgments inside, now it's 9. Part 2 file to good. Two 777. Isn't it? So your second file is it? Your petition. You see file C. E to good. E to good. Yes, Mr.
Lordship, my humble submission is that the 2005 judgment was not contradictory.
No,
to
no,
the-
let us hear it finally. You give me the total thing. We have been just exploring possibilities till today.
Yes, Lordship.
So now today we will finally lock down on a possibility. Probability. You
Lordship,
make your submissions.
Lordship, yes, it is true that as per the Panchayat Act, that it should be, the election matter dispute should go to the tribunal.
Hmm.
At the time of this filing of the instant petition,
Hmm.
there was no tribunal.
Hmm.
Admittedly, there was no tribunal. Lordship. So far as petitioner number 1 and 2 is concerned, they are not candidate.
Hmm.
So they can come to the High Court.
So present
so
writ
far as-
petition is only with regard to,
3 and 4. 3 and 4, they are
you are not
candidate.
pressing this petition for
No,
1 and 2.
I would like to withdraw this for 1 and 2, Lordship, with liberty. To file. And so far as 3 and 4 is concerned,
We
Lordship.
are not giving you liberty. We can only delete here.
Yes, obliged.
Only delete.
Obliged. So far as 3 and 4 are concerned, on the date of filing the instant petition, there was no tribunal, Lordship. As because there was no tribunal, where they will go, Lordship. So they had filed this petition. And during the pendency, the Revenue Department has also stated before the court, it was in the record, in the order of the court, that the same is in the process. And when the process is completed, that has not been communicated to this court, Lordship. Only on the last day or day before the last date, it was communicated, and on the last date, they have shown a notification, Lordship. So,
Misjoinder of parties is also a ground of dismissal. Even if we think that this is a alternative method you have adopted
Lordship,
to the provision in the Panchayat Act
Lordship.
of preferring a writ petition, of election petition before the tribunal.
Lordship.
Now, even if we think that this is an election petition, misjoinder of two parties.
Lordship, election department, election commission, the court
No,
has already.
this will be akin to that.
Yes,
Akin to that, then why the 1 and 2? Because there is a clear bar for any candidate, anyone to institute a election petition who is not a candidate. So this 1 and 2 incorporation herein, you have a misjoinder of parties.
No, Lordship, in respect of this Ranjan Gogoi case here, of this High Court, the High Court has passed an order that any
That
person
is
who has-
prior to the elections.
Election being held.
No.
The Ranjan Gogoi is prior to the election.
Prior to election, but it was observed that the 1 and 2 can come after election.
Oh,
This,
that is
those-
different. That is different. But here, you have come here challenging
Yes, Lordship.
the elections only on the ground that there was no election tribunal available.
Yes, Lordship.
So you have instituted 3 and 4 were candidates accepted. But what about 1 and 2?
Lordship, I'd like to again submit. For 1 and 2, after the election, the 1 and 2 can come.
They
As
can
per the
come.
Ranjan Gogoi, Lordship.
Okay, then we will take it as a petition for 1 and 2. We will not consider as that for 3 and 4.
Lordship. So far as 3 and 4 is concerned, here is the
We'll
part.
consider it as 3 and 4.
But,
You
so-
will
so my
consider this
submission-
petition for 1 and 2.
Lordship, for me, I can submit that for 1 and 2, it is maintainable. But still then, as because the.
We'll not permit because we'll consider this to be an election petition.
Yes, that's
Filed
why.
before this court, not before the tribunal. And if that be so, only 3 and 4 will be eligible. And not 1 and 2. Otherwise, it will be 1 and 2, not 3 and 4. Both cannot come together.
Lordship, that's
So
why.
we will treat it as a petition filed by 1 and 2, and we will consider the matter. 1 and 2, we have the power to consider.
Lordship,
1 and 2, we have the power to consider.
yes, Lordship, that's power. As because, Lordship, as because for 3 and 4, there was no forum at that particular.
That they can't
that's
help
why.
it. They have, when the forum was there, they have not utilized it. So we'll not give it any credence now. But 1 and 2, the petition is maintainable. Yes.
Lordship,
Ranjan
for
Gogoi
1 and 2, we are going to withdraw, Lordship. We pray for withdrawal for 1 and 2 as because
We
for
can't,
3
we
and
can't permit that because this is a election petition. If 3 and 4 is to be continued, we will treat it to be an election petition. Striking of name would come in by way of an affidavit or by way of a IA. You will have to file. We'll have to be given a, now it will be an election petition. We'll have to construe it to be an election petition if 3 and 4 continues.
It's up to the court.
No, no, it's not up to the court. I'm talking about a technicality.
My lord, this case was filed by one non-candidate, my lord.
Yes.
That was dismissed. Very recent.
This is a different issue altogether.
This case was filed by one and non-candidate.
That's why I'm saying.
Yes.
Two non-candidates, two
Yes.
candidates.
Yes.
So this writ petition now will either be of candidates or non-candidates. Cannot be both.
My lord, one small point, my lord, as the deliberation is going on, possibly 3 and 4 together may not come in, my lord.
It should be one.
Yes, it has to be individual with individual affidavit.
Affidavit. Mr. Ullah,
Yes, sir.
that is also a ground
That is,
because this is an election petition.
that is true.
You can't have many people here. One, because it will be his statement that
Yes,
has
sir.
to be verified.
Yes.
So everything goes, your whole writ petition is bad.
Lordship, so far as 1 and 2, I again.
1 and 2,
Yes.
maybe because it will be a writ petition only,
Because of,
maybe we'll have to have that liberty
yes, Lordship.
to not apply the strict provisions of the Representation of People's Act. But 3 and 4 will go, cannot be there.
So far as Lordship 3 and 4 is concerned, Lordship, I would like to say that as because there was no.
Then I can't
forum.
hear you, 3 and 4, because 1 and 2 are there. And 3 and 4 have not filed separate affidavits. And another interesting thing. Okay, affidavit is by 4. So there is a bar. It will either be 1 and 2, no issue, or it will be 3 or 4. It cannot be 3 and 4.
Small point, 1 and 2, there is also bar, my lord.
That's a writ petition.
Yeah, but if you leave 3 and 4, then who is the affidavit?
Not on that. That we can, that you leave it to us. That we will take care. Because affidavit is
Yes,
it can be,
I understand.
there is a judgment also to that effect. Supreme Court. Mr. Ullah.
Yes, sir.
That day I was with you, but yesterday when I was going through, these bad ideas came in. What should we know?
Lordship, so far as 1 and 2 is concerned.
We can't permit you to withdraw because we'll have to treat it as, because you want us to send this there. So
Yes,
this
sir.
will have to be treated as an election petition. Not filed there, but filed here. Then you will have to explain 1 and 2 is a misjoinder. And that's a ground for dismissal.
Lordship, when the jurisdictional matter comes, when there is no forum, Lordship.
I got it. The person who has the eligibility or who is entitled to approach that forum,
yes, Lordship,
can only come here. Nobody else can come.
Yes,
Say a
yes,
candidate has a power, has a entitlement to prefer a election petition,
yes,
right? That entitlement is qua the candidate,
yes,
cannot be in respect of anybody else, right? So anybody else cannot be tagged along with him to prefer this.
right, Lordship.
Now, the challenge to the election petition cannot be a joint challenge. It has to be an individual challenge. So it is either 3 or 4. Cannot be 3 and 4.
But at the same time, 1 and 2, the writ petition for 1 and 2 is maintainable, Lordship.
So you delete 3 and 4, we will consider 1 and 2. You file an amended petition for the...
Lordship, a time may be granted, Lordship.
This matter was fixed today for final consideration. Also, during the deliberations, the very issue of very maintainability of the present writ petition had arisen. inasmuch as the present petition has been filed by by petitioners number 1 and 2, who are admittedly not candidates, along with petitioners number 3 and 4, who are candidates. There seems to be a misjoinder of parties in the present writ petition. Further, the prayer of the petitioners is to remand the present writ petition to the jurisdictional election tribunal. Such remand would only can be made by a candidate, not by a non-candidate. Further, the present writ petition, even if a present writ petition is found to have been instituted by 2 candidates together along with 2 other non-candidates. Also, as the issue of maintainability has arisen in the present writ petition, Mr. D. Learned Counsel for the petitioner prays that he be granted further 2 weeks' time to examine the issue and make his submissions in the matter. Prayer accepted, a registry to list this matter after 2 weeks. The matter be not further considered as a tied up and/or parted matter before this court any further. Come back to me, don't worry. I'll hear it.
For clarification, my lord, one clarification. Page number 108, Lordship will find my application was forwarded by the supervisor.
So that is done.
That is done. Through proper channel is signed by the supervisor, forwarded by supervisor. 108 page number.
That site signature is the supervisor's.
Yes.
Huh?
Yes.
Yes, Mr. Cal, what is happening?
Let's see what happened, the earlier guide, he was put under suspension.
That issue your junior has
Yes.
beautifully taken us to that. He did not.
Now, I propose that he has been assigned new guide lots. Now meeting is held on, to be held, fixed on 19th. Everything will be done on 19th. And he has to upload all his work in the website, let's say, that is the.
Why?
Let's say, because this is.
You have asked for, not Mr. Cal, that is what I'm saying.
Lots.
You have asked for the uploading of the PRC reports. How can the petitioner have the PRC?
No, let's see.
Yes, you have asked for. This university, madam, I'm sorry, we are getting very wrong vibes. Come to page 180.
Yes.
1, 2, 3, 4. Show me from your ordinance, where is this
The
required?
revised application contents will be placed.
No, further, 4th paragraph.
Further, the provision of PSD ordinance 2017, you are also directed to upload research advisory committee report in the online PSD portal without fail, and if it is mandatory further academic processing.
Show me that requirement in your ordinance.
Okay. Let's see, page 136. Rule 12 and 13. Page 138. An application in plain paper is to be submitted by scholar to supervisor requesting for presentation of pre-submission seminar, and after completing at least 2.5 years from the date of admission in the PhD, case of PhD, and 10 months from the date of qualifying coursework in case of MPhil, refers to clause 10.5. The report of the seminar should be prepared in Form 10A within 2 weeks from the date of successful presentation. The scholar has to submit an abstract of his dissertation within 2,500 words, along with
duly fill the pre-submission form and fee to the department. The RSA should be ensured the validity of submitted panel before allowing the student to present the pre-submission seminar. If a candidate fails to submit is this within 6 months from submission of Form 10B pre-submission form, the whole of the pre-submission procedure have to be repeated provided it is within the following duration of the course.
Which page, Mr. You just pointed out some page to me, which was that?
My lord,
Page that letter.
that letter,
Page
page 108.
10.
Yes.
Now, Mr. I'll come to 108. This is forwarded by the, you can see at this side, the supervisor's signature. So he has complied with that.
Lordship, this
On-
was before his extension, Lordship.
So now you have given him extension.
Yes, Lordship.
When?
Lordship, he was assigned a.
So now the extension is
19
from which period to which
It will
period?
be decided on 19th of March. Lordship.
So he doesn't have an extension as on date.
Yes, Lordship, because, but Lordship, I talked to the registrar, he said that his case will be considered favorably because Lordship, in spite of the rules of the university or ordinance, Lordship, because he
So
failed.
first thing you have to do is that give him an extension.
Yes, Lordship.
So that extension has to be from the last date
Yes, last.
for 1 year.
Yes, Lordship.
So immediately that extension is granted.
Lordship.
Thereafter, he
Yes.
will have to resubmit this.
Yes, he has to upload all these things to the new.
Now tell me, where is the requirement of 180 PRC reports, RAC reports?
Lordship.
Because this is by the head.
Lordship.
So she knows everything.
Yes, Lordship.
So show me that this reports, RAC reports, Research Advisory Committee reports have to be uploaded. From where? Because what you took me through page 139.
39.
Presentation.
Oh, Mr. You are expert now. Let me also be understanding. 38, yes. 13 and 14. I don't find any PRC reports required there. RAC reports required there. From where did your this head of the institution get this? Head of the department, sorry.
Head of the department. She is referring to PSD ordinance 2017. If it is not there.
First and foremost, an extension has to be given to you. Then only these things will be able to be done. So he says that 19, the extension will be given to you. If the extension is given to you on 19th, then your application gets revived because that was submitted within the period of validity before 13/1/23/1 or 13/1/26.
On January 26.
January. So that application gets, we provide, we'll ask, we'll undertake, we'll direct that the formal orders, formal decision, we'll say that you will be given extension. But the formal decision will be made by the BRS. What is that?
DRS.
No, see, by the
Departmental Research
19th
Committee.
is the meeting of?
DRC.
No, 19th is the meeting of?
Lordship, Board of Directors.
By the BOD. By the board.
Board, Lord.
Board of BRS.
Page 144 and 145. 145 circular. His affidavit, 145 page. Not very clear, my copies.
BRS, SA, that is the meeting.
Lordship.
So once that is done, then only we can take the matter because now you don't have an extension. So we will wait till, we'll fix this matter on 20th.
My lord, my lord.
And then we will direct on 20th that this earlier application automatically gets revived. Or we can make that observation today also.
Yes. And let's fix the matter on, make the matter on 20th or 21st.
21st. Okay. Third day, Learned Council for the parties. Mr. S.C. Cal, Learned Standing Council, Agriculture University.
Assam University.
Assam University. On instructions has submitted that the extension granted to the petitioner. Where was that, Mr.
Page 91.
To the petitioner for completion of his PhD course till had expired on 23/1/2026. He submits that the matter was thereafter processed basing on the application submitted by the petitioner, and the university in principle have decided to grant him further extension for 1 year.
Not.
Also, however, for 1 year, and the said aspect of the matter would be formally announced, would be formalized in the 67nd meeting of the BRS bracketed science, which is now scheduled to be held on 19/3/2026. Mr. M. Nutt, learned counsel for the learned counsel appearing for the petitioner, by referring to the requisites to be performed, requisite steps to be taken for pre-submission of the seminar, for making presentation of pre-submission, submits that an application in the plain paper was already submitted by the petitioner. Page 108. On 15/12/2025, requesting for organizing a PhD pre-submission seminar before the chairman, RAC/DRC/BPGS, Department of Agriculture Engineering, and the same was forwarded by the supervisor now assigned to him, right?
Yes,
Now assigned to him,
Dr. Avinash Kumar.
Dr. Avinash Kumar. Also, on the extension being formal, extension of period for completion of PhD by the petitioner being formalized on 19/3/2026 by the concerned committee, the respondent authorities shall thereafter process the application dated 15/12/2025 submitted by the petitioner for organizing PhD pre-submission seminar, inasmuch as the said application was made during the period the earlier extension granted to the petitioner was in currency. Also, Mr. S.C. Cal, learned standing counsel, Assam University, shall on the next date of listing the developments taking place in the matter after the passing of the present order. Also, registry to list this matter again on, we'll have it on 25th, on 25/3/2026.
Obliged.
Mr. Cal, we don't want to disturb you. We find her to be very competent and she is updated. She reads the brief very well. You have guided her well. But the thing is, sometimes these observations, we can't make it in her presence. It may not be nice for her. That is why only, it was not because she was not assisting us. It was because I did not want to do it in her name.
No, definitely.
Now doing it in your name, we have no problem.
Yes. Lots. Obliged, my lord.
And madam, continue studying, reading.
In this case, the services of the petitioners were dropped, my lord, while provincializing the services of the other staff of the schools, my lord. Against their name, my lord, post was sanctioned. But at the time of final provincialization, their names were dropped. Totally reason, my lord.
Final order, your name is not there.
My lord. Affidavit was directed to be filed, my lord. They have given the last.
Today
chance
there is
also.
nobody.
Last chance also.
We'll ask the registry to take up the matter with the Director of Elementary Education.
My lord.
Mr. Ayat Soikia, Learned Counsel for the petitioner is present. There is no representation.
Secondary, my lord. Secondary.
Secondary education. There is no representation on behalf of the secondary education in the matter, although this court had granted time to the Learned Counsel appearing for the secondary education department. Oh, it took a lot of decisions. But Mr. Ayat Soikia, none appears for the secondary education department. In the present petition, notices were issued on 5/4/2021. The matter was thereafter listed on 22/4/2021, wherein on the prayer of the Learned Standing Council, Secondary Education Department, the matter was adjourned to facilitate receipt of instructions by the said council. Thereafter, the matter was listed on 27/1/2023, when noticing that the affidavits have not been filed in the matter, one more chance was granted to the respondents to file their affidavit in opposition. Thereafter, the matter was listed on 22/2/2023, however, no affidavit was filed, and basing on the request made by the Learned Standing Council Secondary Education Department, matter was directed to be listed after 2 weeks. The matter is found to have thereafter been listed on 6/2/2026. However, still no affidavit was filed, and basing on the prayer made by the Learned Standing Council, a last chance for filing of the affidavit was filed. Filing the affidavit was made, and the matter was directed to be listed today. Today, when the matter is listed, there is none. Yes, madam.
Lordship, my senior is on legs.
Who is your senior?
Mr. B. Kaushik, Lordship.
B. Kaushik, can't help it. There are many other advocates, departmental councils. Nobody is here. So we are imposing 50,000 cost on you.
Lordship, after some
You have
time,
nothing to
Lordship.
do. Huh?
After some time, Lordship, some accommodation.
Okay. Okay, sometime. We'll not finalize it. Dekha. Today, when the matter is listed, there was none to represent the secondary education department, and it is not found. And it is not, and the affidavit is not found to have been filed. The matter has been, the final consideration in the matter has been delayed only on account of the non-cooperation on the part of the authorities of the secondary education department. And this is found to be a common feature in all the matters, in most of the matters which are listed for consideration by this court. In view of the above position, this court, being prevented from dispensing its discharging its duties in considering and disposing of in resolving the grievances raised before this court, would now proceed to consider the issues arising in the present petition on the basis of the materials available on the record. For the default on the part of the respondent authorities, this court directs the Director of Secondary Education to imposes a cost of rupees 50,000 on the Director of Secondary Education, Assam. Also, we'll hear the matter when Mr. Kaushik comes. Mr. Kaushik is.
Cost may be.
The cost I have kept it, and if the affidavit comes, I'll withdraw it. If not, that will remain, and we are disposing of the matter basing on the submissions made by the petitioner. You can inform him.
The last occasion, my lord, my learned friend was to inform when she had joined.
Who? The private respondent.
Private.
That's a promotion transfer matter. It is it.
Where is that joining against the post at?
Lordship, the last page. Charge report.
Who is this?
Lordship, this reflects that initially there is a decision taken by the SMDC that since the post is life vacant and she's the senior most eligible.
That is that.
On that.
No, I'm not on that. That is in chargeship.
No,
Now that you have.
order was passed on 28. Order was passed on 28.
I'm sorry.
And I
That-
charge on 31st.
Where is the order? Why the senior most assistant teacher of this school, why, where is the order of promotion? Page?
Page, my lord, 32. Lordship, you'll find that was passed on 28.
28. Right. So how can you take over charge on 15.3?
No, Lordship, 31-3.
No, that is in reference to a communication.
15-3.
15-3.
IS passed an order that since.
That is in charge.
Yes, Lordship.
That is
But-
nothing.
But this is, Lordship, is a schoolboy error, Lordship. Schoolboy error, slip up, merely slip up.
No,
Ought to have, ought to have written.
Because
the-
you could not have been done. It could
Why
not have
not
been
written
done
it as the order?
because you were not promoted in that school.
28, Lordship, 28.
Show me, Mr. Chakraborty, that from the order at page 32, you were promoted at Longnit. Show me.
And I took charge in the long lead.
Where? This
Charge
is,
report.
this is not a charge report. This is with some regard to some 15-3-2022.
That's-
When did you hand over charge? Where is your handing over charge? In when Mr. Durgeshwar Soikia came to take over charge from you?
Lordship,
Where is that? Durgeshwar Soikia is to move first.
Lordship.
He has to approach you. You have to hand over charge. Where is that document?
Let the IS make that clarification.
It's not there. It would have come.
My lord, I'm clarifying, my lord. My lord, post of my lord, headmaster of the Longneet High School was vacant due to the retirement of incumbent of Pulin Chandranath, my lord. He retired on 31-3-2022, my lord. So, my lord, initially
31-3?
2022,
Are you sure with that?
my lord, my lord,
21 nahi? 21.
22,
31-3?
2022, my lord.
So, Mr. Chakraborty,
No.
how have you taken over charge when
My
the
lord.
post was already filled up?
No, not fill up, my lord. My lord, that my lord, she was allowed to initially hold the charge of the my lord, headmaster, my lord.
But he is there till 22.
No, my lord.
You say till 31-3-22 he is there.
Not my lord, that charge report, my lord, Lordship will look into the charge report,
Mr. Pulin Chandra Nath was in the school, Longnit,
my lord.
as headmaster till 31-3-22.
2022, my lord,
Sure.
my lord,
Then how can she be promoted on 28-3-2022?
my lord, as the vacancy will occur on 31-3, my lord, 31-3-2022. Pulin Chandra Nath was the headmaster of that particular school, my lord. And my lord,
Mr.
Lordship
There
will
is
look into,
some mistake with your date, it seems.
Lordship, I'll clarify it, my lord. If you want to march would go link Kali, na? We have annexed, my lord, no, more affidavit can do.
Your Lordship may come to page 58, my lord.
will come.
Five.
Mr. You have been fed a wrong date, Mr. Chutia.
My lord, lordship,
The date is, daytime date of Pulin Chandra Nath is 30/11/2021.
Yes. My lord, my lord.
Otherwise, the whole thing, I could have just finished it off, Mr.
My lord.
Lordship is correct.
My lord, my lord.
So,
Yeah, my lord.
the post is vacant.
18/11/2021, my lord.
The post is vacant.
My lord, post was vacant, my lord.
Vacant.
So
Now, where is this letter of 15/3? It's on record.
I'm taking over search from Jatin Chandra Hendrik, my lord. Not Pulin Chandra Nath, from Jatin Chandra Hendrik, my lord.
Where, who?
The seniority list.
The seniority list, my lord.
Is the,
Senior
he was
most
acting
teacher.
as a HM.
Yes,
Okay.
my lord. So,
I do hand over charge. This is by
my lord, the documents, my lord,
Headmaster Lungnit High School.
lordship will look into the order, my lord, 15/3/2022 order.
Where is that?
My lord. Ekhon detail. From Jatin Chandra Hendrik, not Pulin Chandra Nath, my lord.
Fine. Because Jatin Chandra in all probability did not have the eligibility.
My lord, my lord, my lord. So the post was lying vacant, my lord. So the private respondent was allowed to hold the charge of the headmaster. And she take the charge from Jatin Chandra Hendrik, my lord.
This
on
is
31st
in
June.
charge.
In charge, my lord.
So this is not in pursuance to 28/3.
My lord, that in the charge report, my lord, they have mentioned about that order, but the promotion order was on 27. my lord.
Okay, but the promotion order, this is not the charge taking against
My lord,
28/3.
my lord, lordship may consider, my lord, whether the any violation of the fundamental rights of the
Yes,
petitioner.
fundamental rights have been violated
My lord, the
because
petitioner does not.
the decision of the government not to fill up posts wherein 10 years have not come in.
My
One. Two, you yourself said that at the relevant point of time, we were considering school-wise seniority.
My lord,
Promote her as Longnit.
my lord,
Thereafter, transfer wherever you
my
want
lord,
to.
that has been done, my lord.
That has not been done.
My lord, that has been
Show
done.
me from the letter.
My lord,
Show me from the letter at page 32. From the order at page 32.
my lord, the proposal, if your lordship look into the proposal submitted by the, my lord, and the, my lord, that is the joining report of Bobita Ingtip Kathapi, my lord, on 5/4/2022, my lord, at my lord, Cleardeep High School, my lord.
Show me.
She joined on 5/4/2025, my lord. And this is the application for transfer, my lord. That she is a single mother, my lord, with two child, my lord. So humanitarian consideration, my lord, she was
He has to be
transferred,
posted here.
my lord. So that is the my application, her application in the third life. Moreover, I would like to report that.
One thing.
My lord.
From when, where is a pay fixation order in the scale of headmaster school?
Yes.
Grade of headmaster.
Well,
that much if you can get a printed copy also will do. You can just, you also may have, or you may not have.
My lord.
From the date the fixation of pay was made in respect of the Mr. Chakraborty school.
Yes.
That much only.
My lord.
When can you get it?
Friday?
Friday. On the heard the Lana
No, by
Council.
Monday, my lord.
Monday.
Monday, my lord.
Heard the Lana Council for the parties at
If you lordship allow, we can bring all these things into by way of affidavit. my lord.
Affidavit, Mr. Chakraborty. Why take trouble?
No, all this by as
Again,
we
it
are.
will take another year.
No, no, my lord. By Monday we can file it, my lord. If
Okay,
it is
Mr.
by
J.
Monday we'll file
Chutia,
it. All this
please.
would bring it on
Mr.
record.
J. Chutia, Learned Standing Council, KAC, submits that certain vital documents have been left out, which he would like to bring on record by way of filing an additional affidavit. Prior accepted, registry, prior accepted, the additional affidavit be filed.
Monday we'll
Before,
file it.
no, it will be a very short time for you. Before 3/2026. The KAC authorities shall also, in the additional affidavit, bring on record the pay fixation order of the respondent number 5 in the post of headmaster, in the cadre of headmaster, post of. Registry to list this matter again on 24/3/2026.
As part of my lord.
For further hearing.
Obligement.
Just show me that you had sat in that chair. That will
Yes.
Lordship, this is the matter relating to drop teacher. The school provincialized thereafter of, in terms of office memorandum, I have qualified. At that time, I didn't have the
High
qualification.
power committee.
No, no, madam. Madam, in
As
this case, I
concerned-
am paying for madam some little accommodation. Madam, I have received a affidavit, madam, without annexa, madam. Let the matter
Lordship,
make.
the number of times were granted to them, your lordship. They are not filing their affidavit. By 5/3, they were allowed to file their affidavit, lordship. Direction was given.
She has received it. She'll file it with the annexes.
Lordship, 22, the school got merged with, amalgamated with another school. Lordship, from
26/7.
26/7, he was not allowed to work.
Welcome. Ms. S. Chutia, Learned Counsel for the respondent submits that the affidavit has been received. However, the annexures they took have not been received from the respondent authorities and praise that the affidavit along with its annexures would be filed without fail on or before
I need it, madam, next.
any day on or before 19/3/2026. Registry to list this matter on 23/3/2026. In the event the affidavit is not brought on record, this court proceed to consider the issues arising in the petition, basing on the materials available on record on the next day.
I preferred an IA, your lordship.
Oh.
I was not allowed to continue.
We'll see. Let the affidavit come. Mr. B. Sharma, Learned Standing Counsel, AG, Assam is present.
What did you feel about, huh?
May I please, your lordship. In this case, lordship, a representation letter which has been sent by the principal to the then inspector of school on the dated 10/3/2017 is been missing, lordship. And we can file an affidavit in this matter, lordship, on 4/8/2025 last year. It only came to my knowledge in last year, lordship. After filing RTI application, lordship, then only I came to know that the representation letter has been missing, lordship. It is not in their office, lordship, since 2017. And I have been waiting all throughout these years so that my post should be regularized, lordship. I've worked for more than 30 years in that school, lordship.
What is your up-to-date instruction? You have finished your up-to-date instruction receipt?
Lordship.
You have received your up-to-date instructions?
Lordship. This is an affidavit, lordship. I filed it. And for the ignorance, the RTI, as per RTI application, this has come to my knowledge that it has been missing, lordship. And for the fault of them, I'm suffering, lordship. My post was not regularized. Hardly 2-3 years is left to become superannuation, lordship. This is my case, lordship. So, lordship, it may be disposed of today with an order, lordship, so that I may be accommodated. For their fault of there, I cannot suffer, lordship. I have got judgment. I can rely on judgment, Umar Devi's judgment, lordship. This is one of the relevant judgment where if I work for 10 years and the appointment is not illegality, if I may be accommodated, lordship, in any school, lordship, not in that school also. So I'm relying on Umar Devi's case, lordship. Another discourse judgment is writ petition of this Honorable High Court. Here also, I can also rely, lordship. There is a judgment regarding of Nagaland bench, I think. And that can be also relied, lordship. I am placing this order, lordship. This is a dispose of order, lordship. This I can place so that it will make it easy. This matter may be disposed of, lordship, because it's a big matter. Similar thing, they can accommodate us. Nothing more to say, lordship. This is my case, lordship.
You are getting your scale of pay.
Now I am getting honorary from the respondent number 5, Lordship, committee of the school committee. I am not getting anything.
And
from
that post has been filled up.
Lordship.
That post that you were appointed initially has been filled up.
It is another vacant post, Lordship. I was working.
That is still vacant.
I think not, because in the last month it has been filled up as per my knowledge, Lordship. So I may be accommodated in somewhere else, Lordship. I thought I will be regularized. I was waiting, working. I has been used for 2 times.
Till when did you receive your pay in the scale of pay?
Payment is not my prayer, Lordship. I am for regularization, Lordship.
So
Payment
you
I
will
have-
not answer to that query.
Lordship,
You will not answer to that.
no, I will answer, Lordship.
Then you answer.
Lordship, I'm coming to that point, Lordship. Uh, uh, 2002, Lordship.
From 2002, you are not receiving salary.
No. Till 2031, 5 2002, I
Got salary.
got salary.
And
After
then,
that, nothing.
then nothing. So first appointment is of 91.
Lordship.
Then from 92 onwards, you are honorary.
Lordship.
Show me, a honorary teacher can be continued in a provincialized school. That school was provincialized at that point.
Lordship.
Yes.
Where is the law? That you have a right by working as an honorary teacher in a provincial.
Not teacher, I forget, Lordship.
Forget honorary, honorary.
Lordship,
Sorry,
Lordship.
teacher, honorary.
Honorary.
Where is the power of the managing committee? No power.
No.
And from 92 onwards, you are getting it from the. Okay, we'll have it at the second half. Yes, Mr. Doctor, what is your instructions?
Lordship, I have received some instruction, but the instruction is not complete. Just reiterating that what is the stand of the petitioner in the writ petition. That he was initially the leave vacancy, that leave vacancy was
And
extended.
Mr. Day, you are paying for?
Committee and the principal.
What is your stand?
Has been working since 91, but it's not a regular post or sanction post.
It is against the honor in honorary basis. So till when did you pay him the salaries? The salaries with the scale. Because he was against a leave vacancy basically,
Leave vacancy.
initially. So thereafter, till when, from when have you paid him his salaries?
What has he been paid, Lordship? That specific instruction I do not.
Can you have it by, we'll have it at 2 p.m.
My pleasure, Lordship.
Hmm.
Lordship, I refer to the writ petition, Lordship. You
We
have
have got
any-
it. Now, you were first engaged on against a leave vacancy.
Lordship.
That continued for some time.
Lordship.
Thereafter, page 26, you were converted as, honorary basis. From the date of your initial appointment,
Lordship.
91.
Lordship.
Thereafter, there is a many requests made that you should be considered against the grade 4 vacancy, this, that, provincialized school.
Lordship.
But basis is honorary appointment. But you are getting a nominal amount now. You're not getting a scale of pay.
No, I am getting that scale of the Binod Chandra Boshwa, Lordship. Against the leave.
Till now.
Till now, I'm not getting. Till
Till
now,
2005 you got.
Lordship, 2005, Lordship. 2005, yes, 2002, it was stopped because there was no GPF.
So that
Against fine,
treasury
so it
officer
cannot be
stopped your payment,
Lordship,
naturally.
that's the
Because you
problem.
don't have a GP, you are not a regular employee.
Lordship.
So till date you have not, you are still in service.
Lordship, I am doing now this cook, midday meal cook, and I am getting 1,500.
Yes, Mr.
Getting that from the government.
No, but you have engaged in this man for last 30 years,
30 years,
plus
okay.
years. What is your take?
That aspect. Conviction that he has worked for the.
And the state government has also supported that view. That's what, there is no affidavit, that means they have supported that.
I am paying to one.
12-1. 2-2-2012-1-24. 2-2-24. Not kept it for further hearing, but it's still coming in me. Okay. 15-2-24. Notice issued. Then 23-2026. Wait, this court has got no other work. Wait for you. It seems that your department is not in a position to. Oh, there is an instruction here.
In the meantime, it matter came to Loc Adalat on 29/11/2024, Lordship.
Yes, how is your honorary appointment to be construed by this court? They don't have the power to appoint you on con.
But I have worked more than 30
Maybe.
years. The
Maybe.
judgments are there, Lordship.
Maybe.
And Jaggu's case is there.
Mr. P.P. Dr. Learned Counsel for the Secondary Education Department shall bring on record the stand of the respondents on or before 1/4/2026. No further time shall be granted for filing of an affidavit in the matter. None appears for the petitioner, even on second call. Mr. P.K. Bora, Learned, Standing Counsel, Education Department is present. The petitioner in the present writ petition has prayed for a direction upon the respondent authorities for consideration of his case for appointment on compassionate ground. Also, the father, next, the father of the petitioner, late Niranjan Boro, while working as a chowkidar from a grade 4 in the in Chakropani MV school, had died in harness on 19/3/2011. The petitioner thereafter on 14/6/2011 had submitted an application for appointment on compassionate grounds. Full stop. The petitioner in the writ petition has projected that in spite of projected that although he had within the time frame prescribed submitted his application for appointment on compassionate grounds, the said application was not considered by the constituted committees, and accordingly, the petitioner has been deprived of his appointment on compassionate grounds. Para. Mr. P.K. Bora, Learned Counsel for the petitioner, has placed on record the instructions received by him from the jurisdictional district elementary education officer, which on perusal reveals that the application of the petitioner was placed before the jurisdictional district level committee in its meeting held on 29/5/2013. However, the case of the petitioner was not recommended for the reason that there was no vacant post available within the 5% quota mandated for appointment on compassionate grounds. A copy of the minutes of the meeting of the jurisdictional district level committee, a relevant portion of the minutes of the meeting of the district level committee has also been brought on record, which has been perused. Also, the father of the petitioner admittedly had died on 19/3/2011, and the petitioner had submitted his application on 14/6/2011. Long 14 years have lapsed since the date of death of the father. Pusa. The crisis that had occasioned at the time of death of the father in harness, that is on 19/3/2011, is found to have been overcome by the family, and the family is found to have sustained despite the fact that the petitioner nor any other family member was appointed, was accommodated against a government post by extending to them such appointment on compassionate grounds. Also, the delay occasioning in the matter has rendered the claim of the petitioner, delay occasioning in the matter since the date of death of his father, has rendered the claim of the petitioner for appointment on compassionate grounds to be a stale one. Also, such application would not now be permissible to be directed to be considered for appointment on compassionate grounds. Refer Dr. Tiwari to my DB, reported in so and so. Also, in view of the above discussion, this court is of the considered view that the petitioner herein is not entitled to a direction for a direction upon the respondent authorities for consideration of his case for appointment on compassionate grounds at this late stage. Also, subpara. As none has appeared for the petitioner on call, even on second call, this court refrains from dismissing the present writ petition on its merits, and the present writ petition stands dismissed for non-prosecution. Yes, Mr. Fukan, when was the school provincialized?
My lord, now I have decided to withdraw this with liberty.
No liberty. You have got no instructions. Why are you withdrawing? We will dismiss it for you.
With liberty, my lord.
You don't have instructions. How can you withdraw? Tomorrow there will be a blame on you. Why take that risk? We are there.
Because I am unable to contact the respondent.
When were you appointed, Mr. Paul?
39/97.
97. How were you appointed?
Lordship will find that page 8. Sorry, annexer 8. Page 14.
Appointed by the managing committee.
Yes. At page 18. Page 18. Page 18 and 22 is the relevant factor.
Anything more, Mr. Paul? Anything more?
So if your lordship would give liberty to.
No liberty. We are dismissing the petition. Heard Mr. A. Paul, learned counsel for the petitioner. Also heard Mr. A. Fukan, learned standing counsel, Elementary Education Department. Appearing for the respondents, for all the respondents, full stop. The petitioner in the present petition has prayed for a direction upon the respondent authorities for regularizing his services by providing with retrospective effect, that is with effect from 1/12/2006. Full stop.
My lord, one thing I may submit. Suppose if your lordship dismiss, then if suppose they get any if their prayers or grievances have been redressed by the department, then in that event this order may result in adverse consequence in their career, because they are just 52 and 53 years of age, or they may.
On the prayer of Mr. A. Paul, learned counsel for the petitioner, the present full stop. Not like it. The present petition, on the prayer of Mr. A. Paul, learned counsel for the petitioner, the present who prays Mr. A. Paul, learned counsel for the petitioner, prays that he be permitted to withdraw the present petition on the ground that the petitioners may have in the meanwhile been regularized in their services. Also, this court has perused the materials available on record and finds that the school in question, the school that is Haradatta ME School was provincialized in terms of the provincialized as per the instructions received by Mr. A. Fukan, Learned Standing Council, Elementary Education Department in the year 1977. The petitioner admittedly was admitted in this, was appointed in the said school, was engaged in the said school with effect from 30/9/97 by the school managing committee. It is a settled position of law that the managing committee of the school is not empowered to effect appointments on honorary basis and or any other in any other capacity after the school has been provincialized. Also, however, considering the prayer made by Mr. Paul, which he also submits is on account of the fact that he has lost contact with the petitioners. This court permits Mr. Paul to withdraw the present writ petition. Also, the withdrawal of the present writ petition, however, would not affect the rights of the petitioner in the event they have already been regularized in their services. However, in the event the petitioners are not regularized in the services, no further liberty would be granted for raising the same issue before this court. With the above observations, the present writ petition stands dismissed on withdrawal. Mr. Gogoi is not there.
No, Lordship, Mr. Gogoi is still on legs, Lordship. I had a talk with him, though, Lordship. He's asked me to convey before you an affidavit can file regarding this based on a appeals which has.
Have you given him a notice?
Lordship, yes, Lord.
Notice has been given.
No, regarding the petitioner, Lordship.
Huh?
No.
Then how have you?
In that case, Lordship, your Lordship.
Then you file your affidavit. In the meantime, we will stay only one part.
The order, which if that is stayed, that would be him getting the final.
No, we will only stay the part wherein he has been debarred. Because that is without notice. That is avoid ab initio. We wanted Mr. I don't want to put that in your mouth. I want it to be, get Mr. Gogoi. We'll put it in his mouth. Take it from him, man. No problem. We are here till 4:45. We are here. Madam, I want the order to be passed in presence of Mr.
Regarding stay, Lordship,
Madam, that is the
Lordship also.
I have already decided, but I want to be not Mr. Bhuya because he is not the counsel.
Without any notice, without any explanation, without anything.
I want it before the appropriate counsel. Name of the appropriate
Yes.
counsel to be recorded.
That is why I have been waiting.
I'm sorry, can't help it.
No.
None appears for the petition on call, huh?
No qualification.
It was time being, no?
Send the affidavit to them. I mean, today, Lordship. I will tell tomorrow.
Heard Mr. A.R. Bhuya, Learned Counsel for the petitioner. Mr. P.P. Dr. Learned Standing Counsel. Mr. P.P. Dr. Learned Standing Counsel, Secondary Education Department submits that an affidavit on behalf of the respondents represented by him would be filed by today is 12 by 16/3/2026. Full stop. Registry to list this matter again on 33/2026. The petitioner is at liberty to file a rejoinder to such affidavit that would now be filed by the
Lord,
respondents.
the only difficulty, the school is not functioning, my lord.
Wait for a week. You have waited for 2 years now. Wait for a week more.
My lord. Obliged.
Ms. M.D. Bora, learned counsel appearing for the respondents number 2 and 4 is present. 2 and 5 is. Huh?
Right.
Mr. P.U. Lascott, learned counsel for the respondent number 8 is also present. And Koidia, and is present.
Obliged, my lord.
Call it. We'll consider. Yes, madam.
Actually, my lord, Senior Advocate M.K. Chaudhary sir will appear in this case, my lord. Can it be taken on 19th, my lord? If your lordship is available.
On the prayer of the learned counsel for the petitioner, the registry to list this matter again on 19/3/2026. Mr. P.D. Nair, learned counsel appearing for the respondent number 3 has submitted that an affidavit on behalf of the respondents represented by him has been filed today. Registry to trace and tag the matter. Trace the said affidavit along with the records of the case on the next date of listing.
Obliged, my lord.
Yes, Mr. Ali.
Lordship, in this matter, we were an affidavit. Date for signing and vetting, my lord. We will be filing it. We're supposed to come, but might not today. In the department, my lord. There. Send it today. I'll file it. I've already sent it.
Mr. H, heard Mr. H. Ali, learned counsel. That much only we require. That much undertaking, nothing more. We are not here to dispose of every matter in this first day itself without hearing you. No. H. Ali, learned counsel for the petition. Mr. A. Fukat, learned counsel for the standing counsel, elementary education department submits that the affidavit has been prepared and would be filed on or before 17/3/2026. A registry to list this matter again on 26/3/2026. The petitioner is at liberty to file his rejoinder after the filing of the affidavit by the departmental authorities.
Last order number 22/2026, madam. Your man is going to retire on 31st of March, madam. No fixation, no promotion.
Yes, where is Mr. Upamanyu? You're for?
College Authority.
College. Yeah, we already done it.
No, my lord, their part also there, my lord. My lord, now, my lord, they, so far after fixation, my lord, for the delay of the College Authority, initially it was delayed, my lord. Subsequently, my lord, this similar to petition, my lord, they are also selection grade as well as to promote the associate professor also, my lord. So now, my lord, this I am going to retire on 31st of March, my lord. And my lord, the initial the resolution was taken 2007 itself, my lord. 2011 itself, my lord. And various occasions I filed a representation before the principal, my lord. And main, my lord, the principal, my lord, at the time.
Yes, where is Mr. Upamanyu? We'll take it up. Yes, madam.
Please, your lordship. Lordship, may kindly see page number 22, from where it is clear that the payment of 50% lordship of 6 pay commission, which is arrear, has not been given to the wife who is the wife of deceased government servant, lordship. Page number 22 may kindly be seen, lordship. It was disbursed in the year 2019, lordship, but till date has not been given to me by the principal of the college. And I am drawing regular pension, lordship. But
I copy 20.
Lordship, yes, lordship. Type copy 20.
Dr. Shamim Bezad, that is the husband.
Yes, lordship. They are admitting that I am the legal heir wife of the person lordship. It was disbursed in the month of March 2019, but till date has not been given to me.
Yes.
I mean, against for 3 months.
Hmm.
Actually, I think this was in 2019, my son, not disbursement.
Why?
I've stated my, I think I'm case 27.
No, the relevant para.
Paragraph 4. In my
Presently, petitioner is
Money is with you. Disburse it.
yes,
it
Lord.
was sanctioned, my lord. As my lord.
So it has gone back to the government. Come to para 7. Para 7, page 30. Have you submitted your next of kin certificate?
Lordship, petitioner is living in Mumbai with her only daughter. She is taking care of his old lady, Lordship.
But how will they know? But your name is there, not there in the record.
I am receiving pension, Lordship.
Family pension.
Yes,
Oh, then,
they can disburse it to my
then-
that family pension
then-
account, Lordship. This is the unnecessary.
3, my lord. I communicated. Director of Higher
who is for the Director of Higher Education?
Pension account is there, Lordship. They may disburse it into that account. She is old and ailing. It is not possible for
No, enough. That much is enough. Yes. When did you send this proposal? 28/2. Yes, Mr. Opaman. What has happened? Lady is suffering.
Lordship.
In this matter, I have filed my affidavit today. I give served them a copy also. It's not on record.
Also, affidavit was directed to be filed on or before 6, or else personal appearance of the director.
What do you want? The affidavit or the personal appearance?
Affidavit has been filed, but there is nothing on record, Lordship. They have not denied anything.
They have not given anything. Okay, fine, you argue.
Yes, Lordship.
Huh? What is the stand in the affidavit, Mr. Das?
Nothing, Lordship.
Okay. Mr. A. Fukan, Mr. S.K. Das, learned counsel for the petition, and Mr. A. Fukan, standing counsel, elementary education department, right? Mr. Fukan has submitted that an affidavit on behalf of the respondents represented by him has been filed. However, the same is not on record. A registry to list this matter again on 19/3/2026 along with the affidavit filed by the respondents. You're not filing a rejoinder, Mr. Das. You
Not
can't.
required, Lordship.
19, okay?
Lordship.
Yes, Mr.
My lord,
This is the last order dated 2/2026. It relates to provincialization of.
Yes, what happened? Your names are been held to be considered, entitled to, but the government has yet to.
Recommended. It's already
Now it is under government consideration, madam.
Okay, government is some other council. Who is that council? Call him. I'll ask him.
Madam, no,
Then?
no, madam. Director has placed the matter before the government.
You are the council for the director,
Yes, and the director and government.
government. Now tell me what the government has done after that.
The government said we have not received the instruction.
Okay, you try to get that instruction by 4:30 or we'll do what is required to get that instruction. Matter is pending from 2 to.
Tomorrow, madam.
No, today.
Lordship, my senior K. Kolita is on legs, Lordship. Lordship may take up the matter after some time.
Yes, Mr. Tobildar. When did you communicate? You are for the university. He's been acquitted in the criminal case now. Why have you not revoked that order of suspension? Hmm. Hmm? Hmm. 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 Not your employee. Peter does it, man. He is under suspension, so he also gets upgraded. Is it not? Peter does it, man. Institution need not be there, but this suspension order, 2017. And if the Butterdev University is a creation, is an upgradation of that university, everybody, he's a regular employee. He also gets upgraded. Is it your stand that he is not upgraded? Not upgraded. That is his prerogative. He has waited for the criminal case to be over. He wanted to come back to you with all clean. Sorry, that is not a submission we'll accept. That we will not accept. Criminal case is not there. The basis for placing him under suspension is not there. So, yes. What happened? Now that he'll have to be treated as an employee of Butterdev University. There is no other way out. Yes. Plus. You are getting your subsistence allowance after, when was it upgraded? 19. Okay. The university came into being from 19. 25th of June. Okay. Are you getting your subsistence allowance?
Lordship, I'm not aware. Lordship.
You're not aware. Okay. Call Mr. Kolita. Yes, Mr.
My lord, we have challenged an order, my lord, basically provincialization order, my lord, which I was initially provincialized. That had been, my lord, withdrawn, and later on it had been challenged before this honorable court, my lord. And this honorable court interfered with a, my lord, direction that the my lord has already gone through once, my lord, page
Para
48.
6 and 7.
My lord, para 6 and 7. So, my lord, may I pray, my lord, as this order has been recently been clarified in the music teacher's case, can have some bearing in this issue, my lord.
Can't have.
I have not, my lord, gone through the entire judgment, my lord. If I can bring some thing from that judgment, if my lordship gives me. And
On the prayer of Mr.
my lord,
A.R. Bhuiyan, learned counsel for the petitioner, registry to list this matter again after 4 weeks on a date to be fixed by. The matter be not treated as parted and or tied up matter with this bench any further.
oblige, my lord.
In this case, Lordship, BTC has not filed their response. Their BTC's response is very essential, Lordship, to adjudicate the case, Lordship.
The counsel is with you only. You could have asked him to file an affidavit. Huh?
But his name is there, was there, Lordship.
Oh, he cannot appear.
He cannot appear.
Yes, madam. Service on respond number 5 complete.
Yes.
Miss, you're Miss so and so, learning counsel, you're standing counsel BTC. Standing counsel BTC, prays that she be granted time till date till 2/4/2024 to file an affidavit in the matter on behalf of the respondents represented by her. Prayer is not objected to by Mr. R. Learning counsel for the petition. As the adjournment is made on the undertaking of the learned counsel for the learned standing counsel BTC that an affidavit would be filed on or before 2/4/2026. The affidavit not being filed before this on or before the said date, this court would consider imposition of cost upon the BTC authorities for the default that would now occasion in the event of not filing of this.
Oblige, Lord.
May I please your lordship? Service is complete in this matter, lordship. May it be fixed for admission, lordship. I am ready to.
Oh, you're there. Who is appearing for 5, 6, and 7? You are appearing.
7, your lord.
You are appearing. And you are for?
8 and 9.
Who is 8 and 9?
8 is Marina Baswan. Is Priyank.
Newly implemented. Who is appearing for 5, 6? 5 you are appearing. You are appearing for the BTC. 5 and 6 you will be appearing. Principal, Mr. Counsel, you will be appearing for the 7. Who is for 5 and 6? College? Nobody. Yes, who is appearing for the Education Higher Department? Yes, what is your stand with regard to the respondent number 7's PhD qualification? Okay. The Learned Counsel for the respondent number 8, newly implemented respondent number 8 and 9 has entered appearance and prays that he be granted 2 weeks further time to file an affidavit. Full stop. The other respondents are duly represented. Full stop. Accordingly, all the respondents are duly represented. Full stop. The registrar to list this matter again after 2 weeks on a date to be fixed by it. The parties shall complete their pleadings before the next date of listing. Much obliged.
Please allow, sir.
Mr. Fukon, you are for the petitioner.
Lordship.
Why? Huh? A prayer is made on behalf of. You're for 8. Now, tell me one thing. The marking was for the ODL experience. Huh? You were given marks for that. How? What is the experience in ODL you have? From where did you get that experience for ODL? ODL experience means that you are involved in the preparation of those papers, minutes and all, then sending it to the students, answering their queries. It's a different world altogether, right? Without being there, you will have to convey. Where, how did you get that marks? And if that marks are deducted, you will not be there. How did you get that marks? What is your stand in the affidavit? I don't find any affidavit. And ODL experience cannot be ascertained by asking you a few questions. There has to be an experience. Anyway, you have some problem today. We are not disturbing you. You are for respondent number? On a prayer made by the Learned Counsel for the respondent number 8 for an adjournment in the matter on account of certain pressing personal difficulty, the matter stands adjourned to 26/3/2026.
Obliged.
Offshoot of those.
Yes, my lord, this is will be difficult because those are the people who have been terminated. Now the only point where I don't know to what extent I have to also go through it, education to the extent that before termination, whether I am entitled to get the same equal pay, equal work, because they were
Jagjit
getting
Singh.
a pay scale. That's the only point to be decided by this court.
And
Not
this is
beyond
come
that.
for hearing.
Yes. Not beyond- I have to
Get
also,
the decision of Nasim Banu,
yes.
non-Travers. They have not filed an affidavit.
No.
We'll have to allow this.
Don't do it.
I'm going to do it.
Yeah.
We had enough.
I find it a bit. I know.
I find it the most difficult thing to do.
Yes,
But
that's right.
seeing the response and assistance from the respondents, we are left with
Two
no
things-
other.
Your lordship is right. 2 things I find it difficult. One is, if it is not other side not appearing, very difficult. Second is about the affidavit not being filed.
They were released from service. They were given the.
This is a case filed before they were dismissed from.
Yes, correct.
Yeah, then they were.
Submitly, they were dismissed, but that period that they had served, that right will still be there.
Given that. Given. Therefore, we are under that it has become infructuous.
Where is your instruction from your respondents that you treat it as that it has become infructuous? Just place it on record. Then Why are you making submissions on your own? Because I have not found the councils making submissions on law points after going through the briefs. They always want instructions. So whether you are instructed to make that submission, then don't make it. We'll allow it by saying that this is no affidavit, nothing, and we'll non-traverse. Non-traverse. It's a hearing matter. Why should we give you time? Already come to the hearing stage. And we will say that as we have passed this order because of the affidavit not being there, even the chief secretary finds that this order ought not to have been passed. There were some other reasons existing. He will make the recovery from the officers who are there, who ought to have filed the affidavit. Much also I'll provide. Yes, Mr. What do you say? But Mr. Das is very fair. He does not want an order in default.
This what?
That is the only saving grace. But yesterday night I was ready mentally to dispose of this petition in that line. Not only this, all, wherever it is there.
Give a chance.
Huh? From madam? Higher education.
Higher division isn't it? Higher division higher education.
You are not representing higher education technical department. Mr. A.R. Tabilda, learned Standing Council, Higher Education Technical Department, submits that no instruction has been furnished to him till date by the departmental authorities. However, Ms. M. Das, learned Additional Senior Government Advocate, D.D. Burman, learned Additional Senior Government Advocate, appearing for the government, has submitted that a parawise comments appearing for the respond number 1, that is the Chief Secretary, Government of Assam, has submitted that a parawise comment was forwarded to the Junior Government Advocate Assam by the Additional Secretary to the Government of Assam Higher Education Department. Also, should I say something more? That means they don't have, maybe they don't have confidence. Take it up, check it up. Mr. Tabildar is granted last chance to file an affidavit on behalf of the respondents represented by him, raised on or before 2/4/2024. Raised it to list this matter again on 24/2024. 2026. You have been saved by Mr. Das story.
That part that I have not received is
I'll reflect it.
given the group.
Might have, may have, I will not. You have got it, tell me. Not got it, tell me.
I have not got because I missed it.
Fine. We have written that. You file a appeal. And this is not the anguish of this court for this case. This is an anguish built up for the last 2 weeks. I'll modify it, don't worry. Wasn't he? Yes.
On draft instruction. Petitioner have word FM degree, not MM degree, my lord. Over here, so they have no such person and I know affidavit is.
Mr. Mr. Ayat Saikya, Learned Counsel for the petitioner. Mr. U. Sharma, Learned Standing Counsel, Secondary Education Department, submits that he is armed with he has been furnished with the requisite instructions by the respondents and would file the affidavit on or before 23/3/2026. Registry to list this matter again on 30/3/2026. In the event the affidavit is not so brought on record on or before 23/3/2026, this court would proceed to consider the issues arising in the matter basing on the materials already brought on record. Petitioner is also at liberty to file a rejoinder affidavit on or before 30/3/2026 in the event the affidavit is filed by the respondents on or before 23/3/2026.
This matter will be taken up on Wednesday. It will be getting order. Order regarding fixation of pay.
He's retiring. Then what about you are putting him in from 2007 in senior scale now. Senior scale.
Selection grade.
Selection grade.
My lord, my resolution was taken in 2011 itself, my lord.
So now you will be placed as of 2011. Then what about his associate professor? Why the delay from 2007 onwards, 11 onwards?
My lord, that delay, my lord, due to my principal, my lord.
Principal.
Complete. I'll show this. So everything, my lord. My lord, I'll show all the documents.
Okay. Okay. When was the resolution of the college taken?
Yes, my lord. My lord, it starts, my lord, yes. My lord, from page 36, my lord.
No, from his affidavit, let me see.
All created by the present principal of the college, my lord.
When was your due date, Mr.
My lord,
After senior scale?
my lord, 2007.
Senior scale?
Yeah, selection grade, my lord.
Selection grade. Senior scale was before that.
Before that, my lord.
Okay. When was the resolution taken?
Yes, my lord. My lord, the page 36, my lord, DP was there, my lord.
Okay. When was this forwarded?
My lord, the resolution was, my lord, taken on page 39, my lord. itself, my lord.
Then?
Then, my lord, in 2014, my lord, the annexer IML page 40, my lord, I wrote a letter to principal of the college, my lord. But reply, my lord, page 41, my lord.
So 8/9/2011, the principal had forwarded it.
My lord?
Principal had forwarded it on 8/9/2011. Page 40.
Page 40.
Third line.
My lord, the then principal, my lord, he forwarded, my lord.
Then what happened?
My lord, director, my lord, some documents was not submitted, my lord. I make the application on page 40, my lord, present principal, my lord. And his reply was, my lord, page 41, my lord. In response to your above mentioned letter, undersigned has submitted a query to the director. I don't understand what query, my lord, regarding your promotion, my lord. My lord, thereafter, my lord, the petitioner was, my lord, head of the Department of Mathematics, my lord. He was assistant professor, my lord. So he was, my lord, other person was, my lord, given charge of the head of the department, my lord. I filed a case before the honorable court for the head of the department as well my promotion, my lord. That representation was this piece. Subsequently, I filed appeal, my lord. Appeal is page 42, my lord. Page 42 and relevant portion is page 49, my lord, paragraph 16. The appellant petitioner also urged that his prayer for seeking a direction.
Okay, then what is the delay on the part of the principal?
Yes, my lord, this, my lord, thereafter, my lord, this.
Now till now the matter is before the government.
My lord, yes, my lord, because my lord, on all occasions, my lord, the SCR everything was not sent, my lord.
Where do I get that?
I wrote letter, my lord.
Where is the query raised by the directorate in this connection?
My lord, no, I've sent a letter, my lord, to the principal.
Give me the main thing. Where is that?
My lord, the page 40, my lord, I wrote this letter, my lord.
Mr. Upamanyu. This was forwarded prior to 2026. Why is the government taking such a long time? And there was some rectification of your senior scale also.
Yes, ma'am. That also, it was, my lord, the resolution was there, my lord. So it was also at that time, my lord, it was sent, my lord.
Yes, when it will be granted? On the prayer of Mr. D. Upamanyu, Learned Counsel for the petition, Learned Standing Counsel, Higher Education Department, the matter be listed on Wednesday, on 18/3/2026, on which date Mr. Bhia shall place before this court the orders in terms of the directions, in terms of the undertaking given by him before this court and recorded in the order dated 20/2/20.
My lordship, only page 63, my lord. My lord, there's one letter from the commission.
We'll see. First, get your money, but after the interest. Huh? Your name? Let's say, but yeah, Learned Counsel for the response number 3 is.
We also be taken up on the list because I will obtain instruction. Because lordship, this instruction, lordship.
This lady is a pensioner. The area salary was sanctioned and the college is repeatedly writing to you to get the thing rectified. That's all. The entitlement is not disputed. Huh? And she is around 77 years old. Now you want a next of kin certificate from her. She is a pensioner.
Yes.
What more is required? Then? What is your instruction? Nothing. They are least bothered. Today difficult. See, you have been taking time in this case. First was on 18/6, then 7/8.
8/8.
28/8, 15/10. By the time Mr. Sharma filed his affidavit, the agony cost to the lady, how do we give her some benefit? You're a mighty state.
Only 1,80,000.
Paltry amount for you, but for the lady it might be a big amount.
1,80,000 something, lordship.
Not big for you also.
Yes, I'm big for me, lordship.
Why it has not come till now? That's my question. Why it has not come till now? On the prayer of Mr. D. Upamanyu, Learned Counsel for the Learned Standing Counsel, Higher Education Department, registry to list this matter again tomorrow at 2 p.m.
Deeply obliged.
Can it be on?
Wait. We can ask your director to come online on 2 p.m. tomorrow. Explain why this money was not. You have problem? We'll ask the director. on the prayer, Wednesday, 18, 2026. And Mr. A.K. Sharma, present for the respondent number 3. And he doesn't come, and matter comes before me, 1,89,000 may become 2 lakh, 3 lakhs.
Deeply.
That we know from 2/2/2026, we know that. From 2/2/2026, we know that joint sitting is required. What happened? Okay. Shortly, that is 2/2 your prayer. 2/2 your prayer was that. That is recorded here.
It is within the ground also, my lord. However, due to
Show me.
circumstances.
Show me. Mr. U. Sharma, Learning Council, Council for the Petitioner, for the Learning Standing Council, Secondary Education Department, has submitted that joint sitting of the Education Department along with the Finance Department for a resolution, for consideration of the cases of the petitioners was scheduled to be held. However, for unavoidable circumstances, that meeting could not be held. Submits that the meeting would be called shortly and the cases of the petitioner would be considered therein. Accordingly, he prays that the matter be taken up on 1/4/2024 for further consideration. Also, he assures that he would take up with the respondent authorities in the Education Department for an early resolution of the issues arising in the matter. Also, prayer accepted, register to list this matter again on 1/4/2024. You can take this back, Mr. Shah. What happened first? 15 days. Call Mr. Aisoike. 15 কি order দিলু? পাহৰি গলো নহয় এইটো। 33 so 15 to. You are there in 15. I forgot. Why affidavit is not filed? No, that I forgot. It was by mistake I gave. Why this affidavit was not filed? That FM case, FMMM. Yeah, go to cancel. Why this information was not given from that date till this date?
Inform the department.
Department has not given. I have not imposed the cost on you. I have imposed the cost on the department only. I forgot when I passed this order. পাহৰি থাকিলো এইটো থাকিব এইটো কোনে লৈছিল আগতে মই লৈছিল নেকি তাক এইটো ডিলিট কৰি দিব দিবি এইটো কৰি দিবি মই পাহৰি থাকিলো You have got an advantage today. I forgot. This is not accepted, Mr. Sharma. This is not accepted. Yes.
Lordship, I was in port number 10 that time, Lordship. Lordship, in this case, Lordship, we have challenged the suspension order, Lordship. The petitioner's service was confirmed in the year 2002, Lordship.
Okay. Why your service is in 2017?
Yes, Lordship.
By the Bozali College then.
Yes, Lordship.
And the college in the meantime has upgraded as that some, Bhattode.
Yes, Lordship.
Now, you are getting your subsistence allowance.
It was informed me that 50%. He is
50. Who is paying?
because
You are
Lordship,
drawing that amount.
Because Lordship, if Lordship see the communication, Lordship, the communication between the higher education and the Bhattode University. Page 62, page 61 onwards, Lordship. Page 61.
We got it. But the problem is, who is paying you and from where are you drawing
Because,
that?
I am, Lordship, my appointment by the higher education.
I got it. Whether your services
Yes.
was also included in the Bhattadeb University when it was upgraded.
But I am my service.
So from where are you getting your pension? Subsistence allowance?
Taking instruction.
Whether it is subsistence allowance can be from a post only.
Yes, Lordship.
So you being paid a subsistence allowance, that means your post is continued.
Yes.
Because if we now direct for your reinstatement also, where will you be posted? That's college where you were there, that is not there. Gone. But if your subsistence allowance is coming from the Bhattadeb University against a post therein, that means you have become a member of the Bhattadeb University service. That clarification is required. Yes. Sorry, I disturbed you. Asked you that. Mr. Patwari, his subsistence allowance is being released till date. That is what he says. So, subsistence allowance is always released against a post. So, 2017, his post was Bozali College. 2019, it became Bhattadeb University. But he continues to receive his. So, that post is a post in your university now. I want that instruction because if we pass this order also, quashing again he'll have to come back. Why a grade 4 employee?
Grade 4 employee.
Why he should come back with a fresh writ petition? We'll solve that issue here only. On the next date of listing, the learned counsel for the respondents, learned counsels for the respondents shall apprise this court as to the post against which the petitioner is presently drawing his subsistence allowance after Bozali College was upgraded as Bhattadeb University.
Next week, Lordship.
Registered to list this matter again on 18, 20.
Or
21 I can't because Saturday. That the consent should be there.
17, Lordship.
17?
Yes.
17. 17 will be too short. 19 you have problem. Okay. 23.
As a part of Lordship.
But heard this. Heard Miss M. Dip, Learned Counsel for the petitioner. Also heard Mr. M. Bhuya, Learned Counsel, appearing for the. Learned Counsel for the Health and Family Welfare Department, and Mr. No, it's okay, Mr. We were waiting for you, no problem. And Mr. B. Gogoi. Yeah, B. Gogoi, you are appearing for what? Whom?
My lord, for the health as well as my lord, that.
Heard Mr. Ms. M. Dev, Learned Counsel for the petitioner, also heard Mr. B. Gogoi, Learned Additional Advocate General, appearing for the respondents in the Health and Family Welfare Department, as well as the Srimanta Shankar University of Health Sciences. The petitioner has instituted the present writ petition assailing a speaking order dated 4/2/2026, by which the raised Srimanta Shankar University Health Sciences has proceeded to impose upon the petitioner certain restrictions basing on allegations leveled against him, which were inquired into by a committee constituted in the matter. It is the categorical contention of the Learned Counsel for the petitioner that the order dated 4/2/2026 and or the 4/2/2026 was not so passed, was so passed without any reference to the petitioner. She submits that the inquiry that is now found to have been carried out in the matter was so carried out behind the back of the petitioner without any reference to him. She submits that the restrictions now brought into effect while the order, restrictions placed on the petitioner while the speaking order dated 4/2/2026 has the effect of 2026 has caused is punitive and stigmatic in nature, and the same ought not to have been so passed without affording an opportunity of hearing to the petitioner hearing. Yes, now, Mr.
Orders were passed. This almost to be.
Hmm?
We will see my lord order one. It's directly in against the petitioner.
Two and
Yes, two part lordship may kindly, my lord, because those students are not before this.
I'm not touching that.
Yes.
I'm only 1 and 3.
The only thing is, my lord, what I would say, my lord, that suppose, my lord, in fact, I inquired on the very first day, my lord.
Okay.
Can be done, my lord.
Mr. B. Gogoi, Learned Counsel for the petitioner, on instructions, Learned Counsel appearing,
I will
Learned
take-
Additional Advocate General appearing for the Srimanta Shankar University has fairly submitted that before passing of the order, speaking order dated 4/2/2026, no notice was issued to the petitioner hearing. Also, in view of the above, issue notice returnable 4 weeks. Mr. Gogoi accepts notice on behalf of the respondent's number
My lord,
till 12.
12.
Till 12, huh? 1 to 12. No formal notice, Parveen Ekni. Petitioner to take steps for service of notice upon respond number 13 and 14 by way of a registered post. Also, considering the issue raised, considering the facts, considering the submissions noticed herein above, and admittedly, the speaking order dated 4/2/2026 having been issued without the petitioner put to notice with regard to the allegations existing against him and affording to him an opportunity of hearing, this court, till the next reasonable date, stays the following debarments imposed upon the petitioner. Why the order dated 4/2 notice issued so why the order dated court Miss Dev has prayed for an interim direction. The Learned Counsels for the parties were also heard for on the interim prayer. Also, why the speaking order dated 4/2/2026, the following directions were passed by the registrar, Srimanta Shankar University of Health Sciences. A to A, page 41. 1, 2, 3. Also, In view of the submissions made by the learned counsel for the parties and noticed herein above, and it being brought on record that the said directions was passed by the Registrar Srimanto Sankodeva University of Health Sciences without affording to the petitioner an opportunity of hearing, this court is of the prima facie view that the directions at serial number 1 and 3 above shall remain stayed till the next returnable date. This court has not, this court, it is clarified that the direction at serial number 2 with regard to 4 students whose practical examination was conducted by the petitioner and declared to be failed as annulled. It is clarified that the direction at serial number 2 above has not been stayed by this court, and the same would remain in force. Would remain in force. Full stop. Registry to list this matter again.
Can it be after 3 weeks? Because only on that point notice. I filed my affidavit to.
I was proposing to do that in the first day itself, but she
Let
did
it
not
be
want.
3 weeks.
Registry to list this matter again on on 1/4/2024, 26.
Maybe.
The respondent shall bring on record their stand by way of filing an affidavit on or before the next date of listing.
2nd of
Second, no.
April.
Second.
Publish.
So done.
Publish.
We go.